Chairman Vasquez, yes, I am here.
Great. If you would please call our next item.
The next item is M2, Public Policy Hearings. Update. Impact of public calamities on property tax administration, county boards of equalization, assessment appeals boards, remote hearings. A continuation of discussion and possible action regarding procedural and due process issues in remote hearings to ensure continuity of business in the pandemic and other calamities, protect the rights of all parties, provide guidance, and seek additional authorities or actions if required. Following the testimony of the listed speakers, other individuals and members of the public will be invited to participate. This matter will be presented by Chairman Vasquez and Member Cohen.
Thank you. Members, we are fortunate to have a statewide continuity of AAB Operationals Work Group back to share their expertise and continue their input on clarifications needed in the LTA number 2021-02. 4 key remote hearing issues were identified last month. Member Cohen and I sent you a memo yesterday listing them as number 1, the rights of AAB hearing participants, including due process. Number 2, document submission. Number 3, scheduling efficiencies and notices. Number 4, information request. Our intent is to provide the time today for work group participants to recommend proposals that help resolve these issues. There is substantial agreement on 2 issues, scheduling efficiencies and notices and information requests, but general disagreement on document submission and the rights of hearing participants. We encourage you to seek a consensus whenever possible. All guidance should ensure fair, timely, and equitable hearings, whether in person or remote. Thank you for accommodating our schedule and for your excellent written material and submission in preparation for this hearing. Ms. Taylor, if you would please announce each sub-item, and we'll announce each speaker who will address it. In your presentation, please identify the specific issue you will talk about so that the record is clear, and I will call on board members for their comments and questions first, and then we'll ask the work group members for their questions or comments. And before we get going, let me just ask Member Cohen, first of all, thank you for your leadership in initiating and reopening this hearing. And if you're available, let me have you give us some introductory remarks here.
Fantastic. Yes, thank you very much. Good afternoon, everyone. So I just want to make a couple introductory remarks, Mr. Chair. Thank you. So we began this discussion about remote assessment board meetings way back in April of 2020. And during the following meetings, we engaged in a very extensive listening process to gain input from clerks of the AABs, assessors, taxpayer representatives, stakeholders, the public. We issued our latest guidance in January of 2021 through the letter to the assessors number 002. And then 6 months later, we began a mid-course review of remote AAB hearings. We requested, you may recall, that we requested and received the result of surveys of AAB clerks. And what we did was we subsequently then scheduled our first reopening of the public policy hearings on remote access appeal boards at our last board meeting in September. Now here we are today. We have, back in September, we received extensive public comment from stakeholders. And at that meeting, there was a request for communications to be sent to the board for our consideration. And this is regarding suggested amendments to the guidance that has been given to the board on remote hearings. Since then, we have received a number of communications regarding the subject matter, and the California Association of Clerks and Election Officials, as well as California Alliance of Taxpayer Advocates, they've offered their views and suggested paths forward. And now what's interesting is that now that we are beginning to walk down this path a little bit further, we're beginning to listen to testimony and weighing the public comment. I just want to take a pause here and just remind everyone about the reasons why this process occurred, what brought us to this point, to where we are today. Because in March of 2020, we faced the public health emergency. The governor had written an emergency stay-at-home order. At that time, to date, almost 750,000 Americans had perished as a result of COVID-19. Here in the state of California, we were looking at 71,000 Californians had died. The pandemic was real then, and it's still real today. It continues. So faced with this pandemic, we wanted to provide guidance to local assessment appeals board that accomplished two primary goals. The first one is the protection of the health of its participants in an AAB hearing, right? The preservation of due process rights for all participants, regardless of in-person or remote hearing format. That is the second critical piece of this. So to put all of this in context, on September 16th, a little over a month ago, the legislature recently enacted AB 361. And AB 361 allows until January 1st of 2024 local agencies to use teleconferencing without complying with specified Brown Act restrictions in certain state emergencies. Okay, that sounds interesting. AB 361 also provides similar authorizations until December 31st of 2022 for state agencies subject to the Bagley-Keene Open Meeting Act and legislative bodies subject to the Gloria Romero Open Meeting Act of 2000. Now, the bottom line is that this pandemic is not over. And the legislature has overwhelmingly expressed its views that for teleconferencing, it's an appropriate tool for local public agencies, at least until January of 2024. And the same support of teleconferencing as an appropriate tool has been provided to state agencies until December 31st of 2022. Now, whatever pathway emerges from this discussion today, I think what we need to do is keep in mind the reality that the issue of remote AAB meetings does not occur in isolation, and does not occur and occurs throughout local and state government. So what does all this mean? It is with this context in mind that I look forward to the presentations today. I can't wait to hear what the experts are going to say. I'll have questions, and I'm sure what we will do in the end is determine a path forward for next steps. But I assure you that I'm committed to being mindful and cautious that whatever we do, that we are working in the interest of public health as well as in due process. So with that, Mr. Chair, I turn it back over to you, and appreciate the opportunity to share some of my thoughts.
Thank you for your opening remarks. With that, Ms. Taylor, if you would please call the sub-item A.
Our first sub-item is A, report on communications received regarding remote AAB hearings. Our speaker will be Brenda Fleming, Executive Director, California State Board of Equalization.
Thank you, members. I just want to acknowledge, as was indicated, that we have received communications for today's discussion from the California Alliance of Taxpayer Advocates. There were 2 submissions and also material from the clerks, the CACO representatives. Those items have been submitted and are attached for today's discussion. Chairman Vasquez, let me know if anything else is needed. I'm just acknowledging receipt of the material.
Thank you. With that, members, do we have any comments or questions before we move forward? Seeing and hearing none. Do any of the work group members have any questions or comments for Ms. Fleming? Hearing and seeing, I can't see on my screen, I'm not seeing any hands. So Ms. Taylor, can we check to see if there's any public, do we have any written I think we do have some written comments on this, no?
We do not have any written comments. All materials received were attached to the PAN.
Oh, there are posted, okay. Can we check with AT&T if anybody's on the public line who wishes to speak on this?
Certainly. AT&T moderator, can you let us know if there's anyone who would like to make a public comment on this matter? AT&T moderator, can you let us know if there is anyone who'd like to make a public comment on this matter?
Ms. Taylor, I'm not hearing AT&T. Okay. Are you hearing them?
We are not, but I have confirmation that there is no comment. Okay. No one lined up for comment, so we can move forward.
Thank you. With that, Ms. Taylor, if you would please call sub-item B.
Sub-item B is follow-up report on surveys of responses received from the AABs regarding remote AAB hearings and request to clarify LTA number 2021-002. The speaker today will be John McKibben, Committee Chair, California Association of Clerks and Election Officials.
Mr. McKibben, are you available? Oh, I see you on the screen.
I am available, Mr. Chairman. Thank you. Appreciate, again, this opportunity. My name is John McKibben. I'm speaking today on behalf of the California Association of Clerks and Election Officials, not an individual county. Just before I get started, I do want to thank Ms. Cohen, Member Cohen, for her remarks. We clerks share her concern, and I think everyone's concerned about the public health issues that we're facing today and about due process. As you'll recall, at the board's September 22nd hearing, I reported CACEO's survey of clerks of the board with regard to their experiences over time with remote hearings during the pandemic. I really don't have anything to add to that information that was presented at that hearing, but I do want to again state that based on clerks' varied experience, and they were varied experiences, we're able to draw several conclusions. One, although more difficult than in-person hearings, remote hearings provided counties with a useful tool that enabled county boards to continue to work through a portion, at least, of its pending caseload while promoting the health of the participants. Some 12 of the 31 surveyed counties plan to continue to offer remote hearings in conjunction with in-person hearings as well. And third, if done right, remote hearings do provide both parties with due process as required by Revenue and Taxation Code 616. However, based on the clerk's own experience, the survey showed that additional guidance beyond that provided in LTA 21002 is needed. While we appreciated your board's guidance on remote hearings, we must point out that the LTA has exacerbated an existing problem of long-standing that clerks have talked about before. The experience that we have year in and year out, it's the problem of vacated hearing dates, triggered by last-minute requests, usually by taxpayers, but on occasion by assessors, that blow out the scheduled calendar for the day. And with it, we can't backfill because we have to meet the timely notice requirements, which are fully reasonable in existing law and in the property tax rules. We can't just pick up the phone and tell the parties to show up within a day or two for that hearing. Consequently, we submitted proposed language for a revised LTA in our September 2nd letter to your board, largely with the aim of solving that problem. And CADA responded to that proposal and proposed other changes to the LTA, but also to our language, some of which we accepted, as we noted on record in our October 8th letter, but some that we had to reject in favor of a different, excuse me, but some we had to reject since their language continued to provide that a taxpayer could reject the offered hearing in favor of a different format and would receive a postponement as a matter of due process. Yet under Revenue and Taxation Code Section 616, both in-person hearings and remote hearings are required to provide the taxpayer and the assessor with a fair hearing and due process. Under the Constitution and statutes, the county assessment appeals process is a program of the County Board of Supervisors, the governing body of the county. In our view, the LTA cannot override the Board of Supervisors' authority to decide what hearing formats, in-person or remote, or both, will be used to provide a hearing in which the parties shall receive due process. The state board neither can or should attempt to do anything to do so by any other form of action, whether an LTA or a rule. Further, a county board, whether the Board of Supervisors sitting as the County Board of Equalization or an assessment appeals board created by the Board of Supervisors, simply must be able to control its own calendar, just as the courts do. This has been the case historically prior to COVID-19. COVID forced counties and their AABs and boards of equalization to consider or to implement a different sort of hearing format, the remote hearing format. This change of format does not fundamentally change the rule and necessity of Board of Supervisors controlling it over its property tax appeals calendar, notwithstanding CADA's attempts to do so through a different revised LTA. Clerks are in no position to negotiate away the powers, function, and duties of the Board of Supervisors, and we respect and we suspect, sorry, and with respect, excuse me, we seriously question whether the BOE has that right either. This issue goes well beyond the scope of simply making or providing guidance to assessment appeals about their practices. Also, although our CADA friends strongly advocate for only one of the two parties to these proceedings, clerks and county boards, being the neutrals in this process, must also treat the assessor fairly. We have to treat both parties fairly. Under CADA's counterproposal to our earlier proposals, one wonders what then would be done if a taxpayer demanded an in-person hearing and the assessor demanded a remote hearing. Which of the two equal parties would prevail in a decision as to the hearing format? Would the LTA be fair in awarding that power to one party over another? In this case, the taxpayer over the assessor. It wouldn't be fair if the LTA said the opposite. But ultimately, that decision has to rest with the clerk based on circumstances that exist at the time in that particular jurisdiction and under Board of Supervisors guidance. However, our proposed LTA would also very clearly state that Assessment Appeals Board and by extension clerks are encouraged to grant participants the type of hearing as requested as long as such a request is reasonably feasible as well as available in the jurisdiction. Clerks are already doing this. The clerks that I've heard from and talked to in the course of this project have all said that they make every reasonable effort to try to accommodate a taxpayer's request for a certain format. And that's going to continue in any county that offers both formats. As to the portion of our proposal that the LTA reiterate how important it is that both parties timely submit documents by the county's deadline for this purpose, the clerk simply must have sufficient time to process, copy, and prepare for distribution each document at the hearing. Failure of a party, either party, assessor or taxpayer, to comply causes unnecessary delays and continuances that further exacerbate backlogs and unresolved appeals. We did accept some of Kata's suggestions in this area, but we must have an LTA that strengthens the county board's ability to ensure compliance with crucial deadlines as needed by that jurisdiction. County boards do not seek a one-size-fits-all compliance tool, nor even a requirement that all county boards enact such a local rule of any sort. We merely seek state board recognition of the county board's constitutional right to do so. Thank you again for allowing me to speak to you today. I'll defer to Mr. Thomas Parker to talk about the legal underpinnings of our proposed LTA and to the other clerks on today's agenda who may have some comments to add about their experiences with remote hearings, their concerns about these problems, and how they might best be resolved. Thank you very much.
Thank you. Members, do we have any comments or questions of Mr. McKibben? Seeing and hearing none. Thank you once again. And do any of the work group members have questions or comments for Mr. McKibben? Hearing and seeing none. Thank you once again. Ms. Taylor, do we have any public comments on this item?
Chairman Vasquez,
Yes.
we do not have any written public comments, and we are still having difficulty reaching the AT&T moderator to resolve our issue. So I believe we could continue and then perhaps go back when the issue with the public comment line is resolved.
Okay, well, why don't let's move forward then. And if you would please call the sub-item C then.
Thank you. Our next item, sub-item C, follow-up evaluation of remote AAB hearings, taxpayer representative perspectives and clarification of LTA number 2021-002. Our speaker is Brianne Rabowski, Chair, Ad Hoc Committee on Remote Hearings, California Alliance of Taxpayer Advocates, and partner Pillsbury Winthrop Shaw Pittman.
Thank you. Ms. Rabowski, are you available to speak?
Ms. Rabowski, if you can turn on your camera. Chairman Vasquez, I can see that she has her hand raised.
Yes, she was muted. She's unmuted. Let me see if she's able to speak.
Yeah.
I see her on the screen, but I can't hear her. Ms. Rabowski, can you hear me?
I don't see her on the screen.
Chairman Vasquez.
I see her image. That's it.
Yeah, this is Brenda Fleming. She may be trying, and if I could just, Ms. Rabowski, can hear my audio. Ms. Rabowski, while you're trying to log on, if you could just send us a quick note in the chat on your status. If you're able to use your chat function. A little more clarity about things.
Ms. Taylor, I see a hand on number 16, but I don't know who that is.
Yes, I'm thinking that we need to take a recess to resolve our technical matters. Our public line is has a lot of background noise. So if we could take a quick 10-minute break to resolve our technical difficulties, I think that would be best.
Okay, because I think I got a text from her. She's trying to get in.
Yes, I think Ms. Taylor's recommendation would be helpful, sir. We apologize for the inconvenience, but if we could take about a 10-minute break, we'll circle back with you as quickly as possible to confirm the status, but let's get an opportunity to make sure the public can participate in this discussion.
All righty, we'll take a 10-minute break.
Thank you so much. Apologize for the inconvenience.
Thank you. but that's the sign of the times here with this technology. And now I can see our next speaker, Ms. Robovsky. I could see her, and I heard her just earlier. So, Ms. Taylor, if you would please call our next speaker.
Certainly. Our next item is sub-item C, follow-up evaluation of remote AAB hearings, taxpayer representative perspectives and clarification of LTA number 2021-002. Our speaker today is Brianne Rabowski, Chair, Ad Hoc Committee on Remote Hearings, California Alliance of Taxpayer Advocates, and partner, Pillsbury Winthrop Shaw Pittman.
Perfect. Thank you for having me. And I apologize for the technical difficulties on my end. It appeared as though we had some additional technical difficulties, which is quite ironic given our topic today on remote hearings. So thank you for your patience with me, and I'm glad we were able to resolve all of the technical issues. I want to start by thanking the board again for taking up this issue. It's an incredibly important issue to all parties involved, and it's really elicited some tough topics. We have worked hard at CATA to respond in writing and provide suggestions to the existing LTA 2021-002. I've also worked behind the scenes with Mr. Tom Parker, sort of talking about the different positions of the parties, unofficially, of course, and trying to make sure everybody understands the different perspectives. So we are working hard on this topic, and we appreciate the BOE keeping it front and center. I will try my best to keep my comments brief today, but there is a lot of ground to cover. So I ask you to bear with me. What I'd like to do is I'd like to give you sort of at a very high level what I see as sort of the three buckets, if you will. The first bucket are points where we believe, or I believe, that we've reached agreement. Points where I think we're near agreement and just have a few disputes, perhaps on language or positioning within the LTA. And then 3 points of disagreement. And these points really center around due process. From that point, and I'd like to do that at a high level, from that point, my suggestion, and I will leave it up to the board if this would be helpful, would be to walk through CATA's attachment with the cross language between the parties, with the suggested revisions to the LTA, to go paragraph by paragraph, line by line, to really help you understand this is where we agree, here's where we have wordsmithing issues. Here's a big point of disagreement, here's where we agree. I think that that'll move us efficiently towards an LTA that can be adopted and really honing in on the issues where we're gonna have trouble getting to a consensus point. So that would be my recommendation. At this point, what I'll do is I will launch into the high level outline of the 3 buckets as I've referred to them. And then I'll pause after doing so and ask the board if they want to move forward with working through the track changed versions. So in terms of the 3 buckets, I believe Ms. Fleming did mention at the beginning that we have good agreement on 2 topics. And those 2 topics are scheduling efficiencies. Scheduling efficiencies and notices, as well as the information request sections. So those are sections that are covered by CATA's attachment to its October 18th letter. First on page 6 for scheduling efficiencies, and then on page 7 for information requests. Reading CACEO's most recent letter and reviewing it with the CATA membership, those track changes that are included on pages 6 and 7 could be fully adopted and the parties would be in agreement, is my understanding. In terms of points of just minor disagreement and a little bit of wordsmithing, those points really appear in the rights to in-person hearings, and they cover many different things, but primarily the good thing is we have reached in substance an agreement as to what should occur with the 1604C time waivers of the 2-year statute by which the board must hear cases. So if you recall, in September's meeting, there was quite a bit of discussion around, we'll call them quote unquote bad actors, those that were really seeking to game the system and try and receive a win, if you will, by using the statute of limitations and abusing their rights to choose a type of hearing. We at CADA believe that that is a problem. We agree with CACEO that needs to be addressed. And the way to do that is to require 1604C indefinite waivers anytime that you want to do a postponement associated with the type of hearing that's offered. So I think we've really, in substance there, come to an agreement. I think that it'll adequately protect the boards and the clerks, and is directly responsive to what we were hearing from CACEO in the last meeting. So I'm hopeful there, with a little bit of word tweaking, we can get to where we need and push that to an agreement. That then brings me to the 2 major points of disagreement. And these are the 2 points that are discussed at length in the body of CADA's letter dated October 18th. And the 2 points of disagreements here sit first in the rights of hearing participants and then in document submission rules. So as it relates to the right of hearing participants, we fundamentally disagree that in all instances a remote hearing could afford due process. We believe that taxpayers have a right to an in-person hearing for certain types of cases. And the reason is, for many types of cases, due process can't be afforded by a remote hearing. And if you were to walk through the body of our letter, starting on page 3, extending all the way to page 7, you will find no less than 20 points specifying, providing examples as to how and why certain cases cannot be heard remotely and still afford the parties due process. And they really cluster around certain things. So the first one that is mentioned on page 3 of our letter talks about the lack of meaningful presentation and communication. So the BOE's Assessment Appeals Manual acknowledges that there must be a reasonable opportunity to be heard, which includes such basic considerations as effective communications between the parties and the board members. So the BOE's Assessment Appeal Manual recognizes that meaningful presentation and effective communication are requirements of due process. And we walk you through various points demonstrating why remote hearings could not provide due process for cases that tend to be more complex. And let me back up here just for a moment. I probably should have set the stage a little bit better, in that one of the comments that CACEO made in their October 8th letter, so their most recent letter, was that CADA refers to sort of quote unquote complex cases and then less complex cases that have less exhibits and fewer issues of concern. And the issue that CACEO raised with that is that it lacks specificity. It's too vague as to what would fit within the parameters that CADA was previously discussing and what would fit within the parameters where due process can't be afforded through a remote hearing. So here, the suggestion we've come up with as a preliminary dividing line looks back to language that already exists in the Revenue and Taxation Code. So Revenue and Taxation Code section 1637 talks about certain cases that tend to be less complex that can be heard by an assessment hearing officer. And those cases have particular parameters acknowledged by the code section. They are typically instances in which the property being considered is less than $500,000, or alternatively, that the property being considered is a single family dwelling, a condominium, a cooperative, or a multiple family dwelling with 4 units or less. So our suggestion here in terms of creating a dividing line, and it really is the preliminary dividing line, is that cases that meet these 1637 code section requirements would always be able to be heard remotely. So we think that those cases are small enough and would be straightforward enough that due process could be afforded by doing that remotely. And this is a really critical point because many of the counties that are pressing for expansive use of remote hearings, LA County being front and center in that regard, are really looking at and pointing to the county's backlog and saying, we have a massive backlog of appeals that we have to get through. We've heard from them that they have mass filers, agents that file a large number of appeals for a large number of properties, and then will no-show on them or do, other abusive things, abusing and clogging up the system. By and large, those appeals would fit these parameters. Now, it's not always the case, but by and large. So here we think by allowing those cases to be removed and saying that those cases could be heard remotely, that will address the county's issue while still affording due process to taxpayers. So sort of as a complement to that, we would certainly acknowledge that there are cases that involve properties slightly bigger than that, where perhaps the parties agree that a remote hearing could afford due process. So to the extent that parties agree, yes, we agree to a remote hearing, we think that'll work well. Certainly they could opt into remote hearings to the extent that a county offers remote hearings. And we acknowledge that not every county is going to do that. So I should have started with that, I apologize, but that's sort of an initial dividing line that we are working with. And in terms of sort of laying a little bit more ground and taking a step back on due process rights, I did hear Mr. McKibben point out that we're advocating strongly from the taxpayer's perspective about what due process requires. And I'd just like to remind the board that when we're talking about due process, we're talking about something that's really steeped in not only the California Constitution, but the federal Constitution. And without diving into it too much, and as you are all very, very aware, due process really was intended to protect citizens against the great powers of the government. And one of the main powers of the government is taxation of its citizens. And that's something that runs to the very core of American government. And so here, the due process rights we have, certainly the process has to be fair to both sides, but the core due process rights required by both the federal and state constitution really are intended to protect citizens that are subject to tax, and in worst case scenarios, their properties being taken away when those taxes can't be paid. Those folks have to be given a recourse. They are, in the vast majority of cases, the taxpayer has the burden of proof. We are the ones that have to come in and rebut the assessor's presumption of correctness. So there is a presumption in the law that says the assessor acting as a government official in that capacity is presumed by the Assessment Appeals Board to have done their work correctly. So the taxpayer is already starting from a position where they're assumed to be incorrect. We're assuming the assessor is correct. We now have the burden of proof to demonstrate otherwise. And we do that not only through the presentation of argument, but the presentation of evidence, right? So these cases that we put forth before the Assessment Appeals Board are incredibly important to the protection of our due process rights. To make that, even more punctuated, if you will, when we get to challenge an Assessment Appeals Board decision in court, and we're asking the court to review the Assessment Appeals Board's decision, that review is incredibly limited as it relates to factual issues and valuation issues. Great deference is given to the board, and no new evidence is allowed on factual issues. So really, we are talking about a situation where the taxpayer's rights sit in the hands of the Assessment Appeals Board, sitting as the trier of fact. So I just wanted to lay a little bit more groundwork around that and demonstrate to the board that these are incredibly important things that need to be taken very seriously. So to turn back to what that means about what we're talking about here today, the main topic that we're talking about presently is that certain cases require in-person hearings. They cannot be heard remotely and still meet due process. So I had started to walk you through some of the things in our letter at a very high level that demonstrate why that due process is not sufficiently granted through remote hearings. I went through the first one, which is lack of presentation, meaningful presentation and communication. So here we have an inability to really compare exhibits and walk the board through a comparison of exhibits. The vast majority of complex cases, as I've mentioned to you before, require that not only the appeals board members, but all hearing participants be able to spread out multiple different exhibits, to write on them, to take notes, to understand how they track through each other so that they can get to the crux of the issue to be decided. Without being able to do that effectively, you cannot present your case effectively, and you cannot create an effective record that could later be adjudicated or reviewed by a superior court as needed. And this is really further exacerbated by the fact that the clerk is the one that's controlling the screen in the vast majority of counties. So imagine now we have a case where you want to present multiple exhibits, as I've described, contemporaneously, and you're limited to one document, and you've got to walk the clerk through it and show her, okay, or him, you know, please demonstrate this point, please highlight this point. It's not an effective way to communicate a case, and it doesn't put together an effective record. This again is worsened by the fact that in many counties, the folks don't have these materials in print. And in complex cases, a lot of times the exhibits are voluminous. In person, you bring your exhibits with you, you provide them to the board, you're given multiple copies to the other side so that everybody can follow along. And this is really incredibly important because it gives the board the ability to really absorb the information, and rather than being forced to review only the information that's demonstrated on the screen, one exhibit, the board is able to multitask, looking at the exhibit at full. What questions do they have? What don't they understand? How are these puzzle pieces fitting together? It's impossible to do that in a remote setting when you're talking about a complex case. You also have an inability to effectively use demonstratives or blow-ups. So in these larger cases, almost every case I do has a series of demonstratives. And sometimes they sit behind me as I'm talking to the board, and they're really highlighting big points in the case that I want the board to keep track of, or things that I really want to highlight to the board as these are things that are very, very important to our presentation. You can't do that in a remote setting in the same way. You also have the major concern of delays and objections to evidence. So again, as I've said, the ability to create and protect the record that you would ultimately be left with, that you've presented to the board, is very, very important. If there's a technical delay or a glitch or a timing, even a slight timing delay, you might have evidence presented to the board and therefore part of the record being captured by the court reporter that never should be part of the record, and you didn't have an opportunity to timely object. That's a huge concern. You have other things like the ability to gesture and communicate to the board is severely limited, and that's really difficult as well. You have a scenario where, you know, each side, typically in person, can speak privately to one another. Even the board can take a step back for a moment to consult on a decision or a ruling they're about to make on perhaps a piece of evidence or otherwise. That can't happen in a remote setting in the same way that it happens in person. You have an issue of masks. So in several different counties, I have heard from our membership that the board will sit together in the room. And because of that, because of health concerns, they have to wear masks. Well, now it's really difficult to understand who's talking. which is not only a practical problem, but a real problem in terms of what the court reporter can take down in identifying witnesses. This is further expounded or further exacerbated, I should say, in scenarios where you have all board members together and one party or the other together in the room. Being together in the room with the board when the other party is remote is a huge advantage to the party in the room, and is not something that without, you know, a waiver by both parties should ever be permitted. And it is my understanding that in certain situations, counties have allowed the assessor and the board to appear in person without the taxpayer having fair warning that that's what was going to occur. That's highly problematic. Then we move on to the next broad brushstroke issue. And this is really grounded in Rule 313E that talks about due process requiring cross-examination of all witnesses and materials proffered as evidence. So again, because we're talking about due process rights, because we're talking about a taxpayer that has the burden of proof, they have a right to confront the witnesses and the evidence, and they have a right to do that in an effective manner. You can't effectively cross-examine someone remotely. I think it's really difficult to build the same sort of momentum and cadence that's effective in person remotely. And we have had situations where, for lack of a better term, you have a witness on the hot seat and they're going through a line of questioning where they realize, oh shoot, I'm going to have to answer a really tough question and I'm in a position now that I don't like. And rather than answer that question, we have seen people feign technical issues. We've seen people do all sorts of things, you know, say that there's internet transmission issues, their video went out, just to break that cadence, just to give them time to determine how they're going to answer the question. And the problem with that is you lose the ability to really demonstrate to the board, no, they're not having a technical issue. This is either a witness credibility issue or you've really hit them on a topic that is a cringe topic for them. It's a weakness in their case. That's incredibly important to demonstrate to the board. And it is in fact the board's duty as the trier of fact to assess the witness credibility. And you can't effectively do that when you have this sort of break in cross-examination. You have witness coaching issues. It is very common for people, or very easy at least, for people to be off screen, consulting other people by email, by chat. Somebody could be in the room that's off camera and couldn't be heard. Witness coaching is very easy to see in person. It's almost impossible to see with all certainty in remote settings. Huge issue, because now you have a record that doesn't adequately reflect what's actually happening and who's actually testifying. You also have the ability of witnesses, and thank you for bearing with me. I think these are important points. I know that's a bit long. You also have the right of any party, when a witness consults notes or aids to their testimony, it is that party's right to ask to view those notes and to have those admitted into evidence. That is standard course. But what happens when right now I'm looking at notes that aren't on the screen? I'm talking from notes that are clearly aiding what I'm talking about, but you don't see them. Hopefully it's somewhat discreet to you. So you now lose your right as a party, and this really applies to both parties, to bring that and put that forth before the board. Again, that's a witness credibility issue that is really, really important for a trier of fact to understand. We then move on to the third big topic, which is incomplete and inaccurate hearing records. Here we have Rule 312A saying that all hearings of the board shall be recorded or reported or videotaped, subject to the conditions of Civil Code, Code of Civil Procedure, Section 2025.340. So here we have an obligation for the board to accurately capture the hearing and the evidence that they are considering in making their decisions. Well, we've talked about many scenarios already, and I won't drag you through each, where it becomes impossible for a court reporter or a video recording or an audio recording to accurately reflect what is actually being heard. When there's mass, it's hard to identify or figure out who's speaking or deciphering what they're saying. Even in the case of remote, that can be true. When you have garbled language, that's problematic. Witness coaching that can't be seen on screen, can't be captured on the record, that's problematic. Multiple speakers at once comes with much more frequency in a remote hearing. That isn't captured because everybody's talking at once. Another problem there. Without the ability to have a full record, you have an inability for a superior court or court of a higher power to be able to review the record. And as I've explained, it really is their duty at the judicial level to review the record as it sits and the record that was heard by the board. When the record's incomplete, well, what happens? That ultimately has to be remanded to the Assessment Appeals Board, and the hearing has to be reheard. I can't think of anything that is more wasteful of all party involves time, effort, and resources. And I can assure you through personal experience and an instance in which a case that I inherited after the fact, there was no court reporter, the audio tape for just 10 minutes was lost. That resulted in the board deciding that whole case had to be reheard. So it is a real concern, and it is something that the courts will remand back to the board. I ask that, those resources not be wasted. Finally, we have the board's duty to protect trade secrets. That comes from Code Section 1605.4, as well as Rule 313G2. In these complex cases, it is very, very common for there to be highly sensitive, confidential trade secret information that must be protected from the public. And I cannot tell you how many times I have discussions with my clients reassuring them of the clerks and the board's ability to protect that information, because they truly are stuck between a rock and a hard place where this is business sensitive information that cannot be made public. It would be dire to the company. It happens in almost every case I'm involved in. And I have to tell them, look, the board has a duty to protect that information. We will close the hearing. We will seal those exhibits to the extent that they're confidential from the public. Very easy to do in person. You simply close the hearing door and you seal those exhibits. And you can say with certainty to your client that that information is not getting out. You cannot do that in a remote hearing. You cannot say with certainty who is in earshot of any participants that are on camera. Plenty of people can be off camera or inadvertently in earshot. It's highly problematic. How do you regulate that? And it's very difficult to determine who's actually on the line and whether they're a proper party involved and privy to that confidential information. Finally, we have an inability to monitor participants' behavior. So here we have Rule 302A1 talking about due process requiring taxpayers be given a meaningful hearing. Well, to me, when you talk about remote hearings, for many of the reasons we've discussed at length now, you have a general lack of transparency in the process. Again, you have people in earshot. You have just a different scenario than being in person. You can't adequately monitor, put forth a complex hearing under those situations. Finally, you have, as we're seeing today, little small screens of each person, even when you're obligated to be on camera. And here we only have 4 folks on camera right now, 5 as Mr. Gaines joins us. And so the size of each camera is fairly sizable. When you have a complex case, you have 10 people on camera all the time because they're hearing participants or board members. It is impossible to monitor who is doing what. And it is all too easy for your trier of fact, who is well-intentioned, to start checking emails, to start looking at other things, to answer a text, to multitask. We're all incredibly busy. That doesn't happen in person. And when it does happen, or you feel somebody starting to feel sleepy, you can call a break. That doesn't happen here. So that's just a flavor as to why in a certain subset of cases, due process cannot be afforded through a remote hearing. And I'll move on finally, and I think this one will be considerably shorter, so bear with me again here. The second major issue of concern, again, harkens back to due process concerns. And here we're talking about document submission. So what CACEO has presented at a high level is potentially acceptable, where you have an ability for the counties and the clerks to craft rules around document submission. I think personally, and I think the CADA membership would agree with me, understanding the rules of the game, incredibly important. Those should be in writing. They should be heard, should be understood by everybody. They should be conspicuously shown on the county's website so everybody is aware of the rules of the game. But the point of disagreement comes when those local rules can say whatever they want. And if those local rules are going to say that evidence can be denied, outright denied, not become part of the record, denied, because they are submitted past the arbitrary deadline set by the local counties, that isn't something we can accept. That isn't something that is standard in-person hearings. You don't have early exchange of information. You simply bring your exhibits with you. We've all agreed through this process that remote hearings should mirror in-person hearings to the extent possible. Well, yes, we have the practical concern of there has to be some evidence that must be submitted beforehand, but we're pulling away from in-person hearings. If you layer on top of that a right to deny evidence because it wasn't submitted by a deadline specific to a county, here I think you've really got a situation where you violated due process. So it's inconsistent with in-persons. It's also inconsistent with the remedies that currently exist in the Revenue and Taxation Code. So in the Revenue and Taxation Code, code sections 408, 441, as well as 1606, where you have formal exchanges of information, provide that in those situations that a party presents evidence that was not properly exchanged under 408, 441D, or 1606, the remedy is not denial of that new evidence. It is not denial of evidence. It is a continuance for a reasonable time. And so here, what we're suggesting in CADA's response is if we have a situation where the code says when you don't exchange information you're supposed to, it's not denied, the hearing is continued. We should do the same thing for remote hearings. And we should say evidence submitted after the deadline should warrant a reasonable continuance as opposed to actual denial. And the important thing to recognize here is, unlike exchanges of information under 408, 441D, and 1606, where you actually have a party receiving the information that's being exchanged and has an opportunity to review that, here we don't have that. Here we're talking about even one step further from that. There's no prejudice to the parties because the evidence is only being submitted to the clerk. It's not being provided beforehand to the other party. So there is no prejudice to the other party. So in many ways, what we have in the remote setting is simply an inconvenience to the clerk. And granted, yes, it's an inconvenience. It's difficult to process evidence when it comes in after a deadline. But the answer to that is a continuance, just like you would do under the code. It is an inconvenience. It happens all the time in person. Nothing different should happen in remote. Next is the idea that what has to be exchanged in advance is a gray area. So as the LTA sits, and as it should sit, rebuttal evidence, impeachment evidence, evidence that is effectively responsive to what the other party has presented does not need to be submitted in advance. The problem is, I can tell you, in every case I've been involved in, again, what constitutes rebuttal evidence is always something that the parties argue. Once you're past your case in chief and you're now rebutting the other party's side, the parties always argue before the board, this isn't rebuttal evidence. This is case in chief evidence. This should have been submitted beforehand. It can't be submitted anymore. You can only submit things that are responsive to what the other party presented. We're past that point. So here you're baiting the same sort of issue where it's unknown about what has to be submitted before. So to allow for absolute denial of evidence as opposed to a continuance because you didn't understand that the board was going to rule it wasn't properly rebuttal is not appropriate and inconsistent with the current rules. And then finally, I will say, and then I will stop talking, I promise, a reminder of all of the things that we talked about before. The reason denial of evidence is an absolute affront to due process is because of the differences in the assessment appeals setting. It's because the taxpayer has the burden of proof. It's because we're already at a disadvantage because the assessor has the presumption of proof. It's because the judicial system reviews the existing record without receiving new evidence. Great deference is given to the board's factual determinations. And finally, unlike the judicial system and standard court system, there's no pre-hearing discovery. So what each side is going to say outside of cases that involve 1606 exchanges are surprises. That makes the cases and the fabric of the assessment appeals process incredibly different than the standard civil judicial system. So I ask that the board consider these facts. It's very clear, at least I hope, that we believe these are real threats to taxpayers' due process rights that simply cannot be allowed and should not be sanctioned by the BOE. And the BOE adopting certain select revisions suggested by CACEO on rights to in-person hearings, on document submissions, would put the BOE in a position of violating taxpayers' rights or guiding the local appeals board to violate those rights. And I will pause there and I will thank the board for their time.
Thank you. God, I felt like I was back in school for a minute there. But it's good stuff. Good stuff. I mean, it's a shame. It's, we had these technical difficulties that made it even longer. But I thought there was a question or a hand by Member Gaines, but I think he dropped it. Is that correct? Okay. I just had one quick question, and you kind of touched on it in your last remarks there when you were talking about the document submission. And and I know timely submission of documents in a hearing is a problem, especially when it's late. And it's a problem for us and a bigger problem in remote hearings. While I'm not in favor of cutting off the appeal rights of late party, they should face some consequences. And I'm just wondering what your thoughts are along those lines.
It's really difficult because we're really stuck between a rock and a hard place where the best things we've come up with so far are a continuance, because that's what the code talks about, right? But we also recognize that's not always satisfactory. We have to keep the hearing agendas moving, and we empathize with the clerks in that regard. But what we haven't yet heard from CACEO is what is it that they want to do? What if it isn't a continuance, and if it isn't denial of evidence, what is it in the middle ground that they propose? Because if there is something in the middle ground, we would certainly be very open to hearing it. It's really the extreme, which is denial of that evidence, where we say that's not permitted. Everything else in between, we'd be happy to entertain, but we don't have anything on the table yet from them.
Thank you. And I see, looks like Member Cohen is stepping up.
Yeah, definitely stepping up. I mean, I don't even know where to begin. That was like thorough. Okay, so I'm going to just kind of start broad and then bring it down. And is the representative of the clerk's board, I think that was McKibben, right? Is he around? I don't know. Can you turn your camera on?
Yes.
He's here.
There you are. Hello, John. It's good to see you again. Okay, so questions that I'm kind of posing to you, to both of you. And I'm wondering if the clerks and then Kata could state in really broad areas, where they have some agreement. Is there any agreement? And I'm going to assume that you guys have had, you know, your own private conversations, right? I understand that you have differing perspectives, and that's fine. That's healthy and natural. But I do want to know where they have agreement, and if you have any agreement in proposed language.
Yes, it's actually discussed in our October 8th letter.
Okay.
We go through CATA's criticisms and address them, whether we think that's reasonable and or whether we accept their proposals or whether we agree. If you want, I can try to go through those.
Actually, hold on, John. I'm sorry. My staff just sent me a text reminding me that Tom Parker is making a presentation too.
Yes.
I totally forgot.
A lot of this to Tom.
Okay, so let's go ahead and hear Mr. Parker, and then I'll circle back with questions for the three. Okay. Okay, perfect.
And let me just say, like a procedural point really quick. That was what I was thinking we could do, is sort of go line by line, because I think there are pieces where we do agree or we have little wordsmithing problems, and then the points where we disagree. So I think ultimately that would be helpful.
Fantastic. Okay, Mr. Chair, I will wait.
Good move.
Okay.
Okay. Ms. Taylor, I believe, is it Ms. Parker's next or who's next now?
Our next item is sub-item D. And there is a long list of participants. That's the follow-up evaluation of remote AAB hearings, county perspectives and clarification of LTA number 2021-002. So we have 7 speakers lined up. Alina Kasparian, Acting Chief, Assessment Appeals Division, Executive Office of the Los Angeles County Board of Supervisors. Thomas Parker, Deputy County Counsel, Los Angeles County. Ann Moore, Chief Deputy Clerk, San Diego County Board of Supervisors. Marcy Berkman, Retired Deputy County Counsel, Santa Clara County. Kathy McClellan, Assistant Clerk of the Board of Supervisors, Sacramento County. Kyrene Gonzalez, Deputy Clerk of the Board of Supervisors, Sonoma County. And the Honorable Ernest Dronenberg, President, California Assessors Association and San Diego County Assessor Recorder Clerk.
You had a mouthful there. My question now is, I'm hearing from, or getting some texts from members, as well as even some of the partners here, that we might have a 3 o'clock deadline here, or cutoff period. And I'm wondering, are we going to be able to finish this by 3, or is it appropriate to put it off? I just want to hear from the members, and specifically the speakers that are sitting in the queue here.
Mr. Chairman and members of the board, this is Tom Parker.
Yes.
I really don't think in roughly a half hour or so, you're going to get all this testimony in, to be honest.
I agree.
That's my thinking. So I'm just trying to, I'm kind of throwing it out there. What are our options here? And because I know Mr. Dronenberg has to leave, I know definitely at 3, and he's the last one on this list.
And the most important.
And the most important, you're right. Let me just throw out a proposal then. As I'm looking at this, I don't think there's anything here that we have to finish that's time sensitive, correct?
Chairman Vasquez?
Yes, Ms. Flowers, what are your thoughts?
Well, let me first ask, what are we going to do at the end of the day, once we hear all the testimony? Is it going to be the board direction to revise an LTA? And are we going to have BOE staff revise the LTA? Or are we looking to get agreement amongst the parties and take their agreed language and just copy and paste into an LTA?
Well,
let me tell you what I would like. I would like.
Go ahead. Let me hear your thoughts. Go ahead.
And I know they're listening. I would like for them to continue to hear the testimony and take everything that they're saying into consideration, and for BOE staff, revise the LTA based on their expertise. And I really would want our Mr. Richard Moon to weigh in that LTA as it relates to due process. And I would like to follow the regular protocol of them preparing the LTA and presenting it to the board for board approval at the November meeting. And your last question, I think it is time sensitive because the clerks are saying the existing LTA is causing problems with them getting cases heard. And so if we don't do anything to the LTA, it's going to continue. So I do think that we need to move as quickly as possible. And I'm really hoping that we have resolution by the November board meeting.
I'm with you and I'm sensitive. I'm with you and I'm sensitive to that. I'm just thinking of the logistics and the reality here. Because if we're going to be losing people here in the next 30 minutes, we may not have a consensus. And I'd like to move forward with an LTA, but if there's not a consensus, I don't know how we can do that. Oh, Member Cohen, yes, go ahead.
We can't talk about like how we're going to solve a problem. We need to hear public comment and testimony, and just in terms of process, we can't circumvent it. So it sounds like we need to have another day for the process to fully
to vet it.
Yeah, for the process to fully go through the process. So we need more focused review. We need to have comments first.
So is it I'm wondering if are we able to, we obviously can't go on until tomorrow because we already eliminated that day. So it sounds like our only option is to bring it back at our next public meeting, which I don't know if we can do that before our November meeting, or our November meeting right now is scheduled early in November, if I'm not mistaken, because of Thanksgiving, correct?
Chairman, this is Ms. Taylor. The meeting is scheduled for November 16th and 17th.
Is the 16th?
May I suggest that we continue the hearing? Because I just don't think we can't take a direction. We can't give a direction to staff without completing the hearing. So we need to continue to November, which is whose idea was to cancel Thursday? That's a rhetorical question, but all I'm saying is that it should not have been canceled. We should have just kept it up.
I mean, we went back and forth with that on that one, yes, and we thought I guess staff and we thought we were going to be able to wrap this up today.
Sure, Vasquez.
Should I have been consulted, I would have advocated that we keep Thursday, but I wasn't asked, so oh well.
Chair Vasquez.
I see a hand for Member Gaines.
Yeah, thank you. We had some technological issues that slowed this thing down. How long do we have with AT&T and their time? Could the meeting go a little later? We would have to juggle things around. We'd have to have Assessor Dronenberg speak sooner. But that might be an option, or just wait until the next meeting.
Let me put out a motion and see if it goes anywhere. I would like to move that we continue this hearing until our November 16th meeting, and that it be the first item of business so we can get through this before we start our items that are already scheduled for November.
I'd second that.
Will you a friendly amendment, please?
Let me hear it.
Can we have the constitutional items take place first?
Oh, not a problem. I'm sensitive to the controller, yes. That's acceptable by me, and I'm assuming the seconder is okay with that.
Yes.
If there is a motion and a second, I want to speak against it.
Go ahead, Vice Chair Schaefer, you're on. The motion is before us.
We've been listening to one side. I'd like to hear some of the other side. Also, I think we're paid to be here till 5 o'clock today. Don't we have another couple of hours that we can function?
The reason I put it out there is that I'm hearing from some of the speakers, we're going to lose them. And like you mentioned, if we want to hear both sides, and I'd hate to see us fall short of listening to all those that we need to hear from today. That was my only reason.
Chair, we're like the judges in a courtroom, and the speakers don't tell the judge how late they're going to hold the court open. The court decides how late they're going to serve the people, and I'm for more service to the people. And if the people can't last that long, maybe we. I don't know. It makes it awkward because I feel an obligation to listen to some of the other side too.
I agree with you. The only problem is that unlike a court, we don't have subpoena power, so we can't hold people here until 5 o'clock.
Don't we have a bailiff?
That's my only issue. And I see a hand from actually one of our speakers here and our partners here, Ms. Roboski. I'm sorry, go ahead.
Yeah, I just wanted to offer, and I fully recognize I am not a board member, so I just offer this as an opinion from the work group. I know that I have a hard stop at 4, but I do agree with Member Schaefer that we've spent a lot of time sort of setting up this issue. I think it would really grease the wheels, to use a layman's term, if you will, for the next meeting. If we hear a bit, even if we just start, but between now and 4 o'clock, to hear what the other side is thinking about what Kata has presented, I think that will put us in a better position to move forward in November. And that's just my 2 cents that I offer for your consideration.
I can appreciate that. And also, Mr. Chair, I think I heard that you also had a hard stop time. I just offer that the vice chair has the ability to run the meeting too, and I think we'll still have quorum.
I put it out there, so let's see what we want. So the motion's up. Any other comments or questions on it?
Yeah, could you restate the motion? I don't recall it.
The motion is to continue this meeting, the hearing that we've started here, and the rest of our items on the agenda today until November 16th. It would be put up at the front with the exception of the constitutional items. And that was seconded by Member Gaines.
Mr. Chair,
are we clear?
Yes, we're clear, Mr. Chair.
Member Stowers, go ahead.
So you're saying that some people have to leave. Does that include the first speaker from the LA County Board of Supervisors? Or have they chimed in saying they need to leave at 3 o'clock?
I haven't heard from there's 7 speakers coming up. I haven't heard from all 7, especially the ones in the front. I don't know if that answers your question though.
Yeah, we don't know, and they're not on the video, so their voices aren't being heard. I understand what Member Schaefer is saying, that they should be heard. They've been waiting and waiting, and I think we just wasted 20 minutes of their valuable time debating if we're going to continue or not. So I'm going to be quiet.
Okay. And I see a hand before we vote. I see one more hand here from one of our partners, Mr. McKibben.
Yes, thank you, Mr. Chairman. As far as I can tell from emails back and forth with our partners, most of us, I think, can stay at least for a while. I tend to agree that carrying it over to November might be realistic, but if we can, some of us continue to speak on this until 3 or whenever we start losing members, that would be a good thing. And if any of my colleagues disagree, please raise your hand.
I am available till 4, so I would be available to go till 4. And as a lone taxpayer advocate on the Teams line, I would hope that maybe we would be given the opportunity to wrap at 4, since I am not available after that time.
Mr. Chair, did I hear you say that you had to leave at 3 o'clock?
Yes. Now, if there's a consensus from the members and you want to continue, I can be flexible.
Okay, if you could be flexible, I think we should continue.
Chair Cohen, Chair Vasquez, if you do have to leave, I'll take over for you.
Not a problem. All right.
So-
Well, we still have this motion on the floor. Let me see if it goes anywhere. And then if it doesn't, then we'll continue.
Mr. Chairman,
Oh, yes, go ahead, Mr. Dornberg.
my experience in playing chairman, trying to balance these things. What time are you scheduled to convene on the 17th November?
Actually, it's the 16th and it's 10 a.m. right now.
I thought it might be a later afternoon start, and I was going to suggest you could do the morning.
And we're already in the morning.
All right, let's call the vote. Let's put this.
All right,
motion
Ms.
to
Taylor,
bed
if you
and
could just
move it.
call the vote.
Chairman Vasquez,
Aye.
Vice Chair Schaefer,
Not nay.
Member Gaines,
Aye.
Member Cohen,
No.
Deputy Controller Stowers.
No.
All right, so that
Mike,
fails.
I'm too happy on camera. Keep
We
it
will
straight.
continue the meeting until we lose the members, I guess.
All right.
So we're at with, I think, Ms. Taylor, you announced the speakers.
Rebecca's complaining about how long she spoke.
Whose motion was that?
Hey, Mike, your mic is
Don't
on.
forget to mute your mic there.
Yeah,
Mr. Chair.
Mr. Schaefer.
Member Schaefer, please mute your mic.
Thank you.
We are on
Okay.
sub item D,
Who told me to?
evaluation of remote AAB hearings. So if we would like to begin, we could begin with Miss Alina Kasparian.
Yes, let's go.
All right, Miss Kasparian, are you available?
Yes, I am. Thank you, guys. I appreciate it. I appreciate the time. So I know we have a lot of ground to cover, and I'd like to kind of address some of the feedback Ms. Rabowski provided. So I appreciate the opportunity. So I've got both screens up. I'm going through actually the letter to kind of quickly go over some of the comments Ms. Rabowski made on remote hearings. I will try not to repeat myself from the last meeting. I know we've covered a lot of this, but I do want to say, to echo what Mr. McKibben said earlier, there's some things we've agreed on, some things we disagree on. I think that we all agree as clerks that we would do everything possible for us to accommodate taxpayers. That's never been the question. We have, as you can see, we've spent a lot of time and resources on making sure we've provided some kind of a platform during this difficult time. So with that said, requests for any type of, in-person hearing or remote hearing or vice versa, we would accommodate. We are not saying that we do not want to accommodate. I think that and I know Tom Parker can touch a little bit more on the whole due process topic from a legal standpoint. But I think for us, when we say due process, it gives a lot of authority and power to the other side, where we would feel like our schedule was not controlled by the AAB. Again, it's not to say that this means it's our way or the highway, that we would not provide accommodations if somebody prefers an in-person hearing for complex cases, which we have plenty of flagged that are ready for in-person hearings once we resume. But I think that should be, at the request of the taxpayer, and of course, if we can accommodate. I know there was mention about, what types of cases should be scheduled, remote, and what types of cases should be scheduled for in-person hearings. It kind of sounds like hearing officer versus board hearings, where more of the simple, less complex cases are heard by hearing officer. And I would disagree with that. I definitely understand some of the examples that were provided by Kata. Of course, there are situations where you've got 100 exhibits, several testimony, witness testimony, and sure, I'd be lying if I didn't agree that sometimes an in-person hearing would be more beneficial. And of course, in those cases, we've gone, plenty of requests for people who've indicated so, and we've put those aside to schedule when we resume. But there's also many of complex cases we've heard recently. We've even had 3-4-day hearings, which have gone quite successfully in a remote platform. So I think it should be on a case-by-case basis. It should be made by the taxpayer tax agent. And of course, if we could accommodate, we definitely will. So I don't think classifying applications in a certain way is necessary, especially because scheduling a request is always something been a part of our process. And I think that what one person may deem as complex is not always, true for all. I've had many agents tell me they do not want any in-person hearings anymore, and this is just more convenient for them. And they've had complex cases where we've had personal property, we've had a few oil cases, and all of which have gone successfully. We're constantly working to make things better. I think we forget sometimes, or I at least forget, that this has been a year in the making. So that means that we're striving to making things better every day. Some of the feedback, such as, being able to showcase multiple exhibits side by side. That's a great idea. That's something that we can definitely look into exploring to implement. And I think some of the other points that were made, about in-person and due process and meaningful presentations. Sure, of course, there are challenges in remote hearings, as we saw today. But I think if we're talking about remote hearing issues, we also have to address some of the realistic issues we face in in-person hearings as well. We've had a lot of delays with traffic and parking restrictions, or people getting to or having to leave early to be places because they have to come down to downtown LA, for example. Those are all still issues that we face in in-person hearings. And, some of the other things that were, I'm trying to go through the letter, excuse me. So lack of control over documents, I definitely understand that it's something that we can absolutely allow an agent to do, but we've done a risk analysis, and I think the fact that giving a full control to somebody to share the documents rather than the clerk putting up what you would like to share has its risks, because, people can put up a document by accident that shouldn't be a confidential document, or a document that was not introduced into the system to be fair to all sides. That's why we've elected to do it the way we do, where the clerk controls the screen. Exhibits not available in fine print. That is not true in LA County. We actually have a system where all parties log in, board members included, clerk, taxpayers, tax agents. The documents are all available to them to view on their own screen. They can view it, download it, save it, print it, make notes on it, whatever works for each person. So, I think that is kind of dependent on the county and the resources that are available. Limited use of demonstratives. I know that was also brought up. I would disagree, and I actually think it's been quite better in the remote setting versus in a big hearing room with a poster across the board, as one of the other my colleagues have mentioned. Whereas, when you're in a remote hearing, it's in front of your screen, everybody's honed in to exactly what's being presented. And I actually think that's been working a little bit better for us. I know there was technical issues, and of course that's something that can always happen, delay in evidence or testimony, or the fact that a witness can be coached, or those issues. I think right now, just even looking at me and looking at your face, I think it's quite clear if I'm looking or talking to somebody, if I'm reading off of something, or if someone is simply not paying attention. Those are, yes, it's not perfect, but I think those are all there. And one can also argue, who's to say in-person hearings, the person can be sitting in front of a board member in a hearing room, with public being in the audience, texting them, coaching them, and you're simply looking down at your paper. That's also a possibility. So I'm not saying that some of these things aren't real. I'm just saying there's always another side. Things aren't perfect, but neither are they in person. But there's also a lot of benefits, you know, especially to the taxpayers, the mom and pop taxpayers who don't have big agents representing them. This has been working so much better for them from the feedback that I've heard. They don't have to come down. They feel more comfortable in their home setting, no parking fees. And especially if they're waiting, if there's more than, you know, 4 or 5 taxpayers logged in, they're waiting in the, you know, the comfort of their own home versus coming down here and possibly not being heard. I think, you know, even the comment about masks, I think that most counties would still continue to, implement the whole mask mandate, especially for LA County. So I actually think for us, remote is better. We don't wear masks on camera. Every person is in there either working from their home or separate in the office, and nobody's wearing a mask. And I think the record is quite clear, especially since we're audio video recording and you can see reactions and clearly hear the speakers. Let's see, ineffective cross-examination. I know that was, you know, I kind of talked about that, you know, hiding behind delays. Yeah, of course that can happen. But, you know, for LA County, for the most part, it's either been delays in the beginning of the hearing that we've had to kind of halt to resolve. Very rarely have I seen like a dramatic scenario where the person is being grilled and then all of a sudden everything goes to a halt. I'm sure it can happen, but I think that's an extreme example. And I think in scenarios like this, the way we've kind of combated that is, you know, the clerk gets on the phone right away with the person. We either try to get them connected through the phone. So there's very minimal room for the person to kind of be coached or, you know, cook up something that they're going to creatively respond with. And same goes, you know, for the witness coaching. And I think, again, in person, I've seen people sit with their phones as well. And I think that there's, you know, both sides. There's pros and cons to both sides. I'm trying to make this as succinct as possible. And I think one of the other biggest ones that I did want to touch on is, you know, the protecting of highly sensitive information. That's definitely not true for LA County. Just as in in-person hearings, any evidence that's introduced or brought by any taxpayer, if it's privileged and cannot be heard or open to the public, that meeting would be closed to the public. It would be a private session, closed session, where the board would still have to review, you know, discuss, deliberate, and hear feedback from both sides on why the information should or shouldn't be present. And we do the same thing in our remote hearings. What we have is breakout sessions. We close out the whole meeting and we're able to discuss privately. So none of that would really change. And same goes to the private conversations that, you know, Ms. Rabowski indicated that cannot be had. That is also not true. We have several breakout sessions where the taxpayer wants to speak to the assessor's office. We're able to do that. Board members deliberate private in their sessions. They can even pull up the documents on their own screen in their private session and discuss, same as they would in person. I think that's pretty much as fast as I can go to kind of summarize, since you guys have given us the opportunity to speak. You know, again, I'm not saying that some of those things are not real. Of course, they're real. We have challenges every day. Same with in-person and remote hearings. But, you know, ultimately for us, it's that we're saying the same thing. This is ultimately for the taxpayer, and we want to accommodate them. But I think that we have to take in our you know, business process, day-to-day function in consideration as well. And there's a lot of challenges that we face, you know, on our end that's maybe not as clear to the public, that's challenging for us. So to add on additional requirements of what we can or cannot schedule would just become a lot for us to handle, since we're trying to efficiently go through as many cases as possible. Thank you very, very much for your time. I appreciate it.
Thank you. I believe the next one is Mr. Parker.
Yes, for the record, I am Thomas Parker, Deputy County Counsel in Los Angeles County, and I'm also the LAAAB Counsel. I want to thank the State Board for the opportunity to speak on this as well as on the prior item K item today. The State Board has historically recognized and honored the constitutional function given to county boards of supervisors and their county equalization boards, or AABs, regarding determining and hearing property tax appeals, as what the Supreme Court in Steinhardt noted was an independent quasi-judicial administrative body. I call it the tax trial court. That comes out of the Constitution. And I think that some of the testimony we've heard from CADA implies that the county boards are really somehow not independent or impartial, that we're not serving the same function as a superior court does in civil litigation. And it's a very subtle tone. They talk about the presumption of correctness the assessor has, and they talk about other hurdles that taxpayers have to go through to try and vindicate their claims of being overtaxed. But the AABs are truly independent bodies. AAB members are not appointed with some secret mission from the Board of Supes to try and keep as much money as possible. We are truly third-party, independent, impartial hearing bodies, the property tax trial courts. That's truly what we are. We're not parties in this process, as Mr. McKibben said. You've heard it before, and all I will say is I think Ms. Kasparian put it very well, and Mr. McKibben put it well. We do our very best to accommodate taxpayer requests, not only for scheduling in general, but for what kind of hearing they want in this COVID situation. CADA, however, really is in the guise of due process and their multi-page letter of October 18th, attempting to paint this as giving the taxpayer a veto. I want only this kind of hearing. I want only that kind of hearing. Now they've added a wrinkle to their pitch, which is say, let's use 1637 criteria. And they'll agree that if you use code section 1637 criteria, that those are sufficiently simplistic or less complex or non-complex, that, okay, those could be by remote. But everything else has to be, there's some due process rights, so they say. And that's a very creative argument. But at this point in time, what the CACEO would offer is that due process is required for whatever kind of hearing the AAB is going to give. Now, I don't think CADA would disagree with that. I don't think anybody would disagree with that. But here's what that means to us clerks and boards. That means whatever hearing we give somebody, there has to be the mandatory minimum due process. And Revenue and Tax Code 1616, it's been cited already, but it's worth reciting again real quickly here. It says a hearing can be either remote or in person. So what that really means is a hearing is a hearing, however exactly it is done, so long as due process is part of that hearing format. And unless the state board is convinced that inherently, no matter what, that however they define it, that a complex hearing can never get due process in a remote setting, only then does CADA's argument make sense. But CADA is dancing around the issue that I am highlighting. What the state legislature said in section 1616 and what due process requires and doesn't require. As the state board, and I'm telling you things you already know, you are not authorized as a state agency to make new law. You are not authorized to trim back or reduce what the state legislature has decided is state law. You implement state law. You maybe fill in the gaps a little bit as an administrative agency. But what CADA is trying to do is read into section 1616 language which is not there, and you won't find it in legislative history either, that namely that complex cases should not be heard by remote because complex cases can't get due process from remote. The state legislature didn't say that. So with all respect to the state board, I'm not sure how the state board can say that. Unless you get the legislature to go back and revisit 1616 and rewrite it to say complex cases are not subject to remote. But until that's done, the statute says what it says. Complex. CADA tried to answer that question too today, again, with that 1637 criteria example they threw out. What is complex? Is something that is complex in Trinity County, complex in San Diego, or Stanislaus, or Fresno, or Modoc County, or LA? I don't think anybody would say that's the case. What is quote unquote complex is a moving target. It's a moving target that is dependent on the kinds of appeals that the particular county has, the local economy. Is it a agricultural economy? Is it mostly, is it by and large a mom and pop store economy? Is it a big industrial economy with factories and oil refineries and huge office buildings and what have you? What kind of, that the local economy defines for each county what is and isn't complex. So, and please do not think that in any way I am implicitly insulting or denigrating counties that don't have, say, Los Angeles's. I'm not. I've worked for 5 counties in my career since 1991. I've worked in counties as small as 22,000 total people, where agriculture was king. Now I work in the exact opposite, Los Angeles County. I take great pride and pleasure in having served every single county that I've served as a lawyer. And I respect whatever their individual circumstances are as far as their local economy goes and what's important to them and what's big time and what's complex. At this point, I'm going to talk next about the document submission. I understand the argument as a lawyer saying that exclusion of evidence is not a fair penalty and goes against due process if you violate the electronic submission of document rules that that county uses. I understand that point. Nobody, I have not heard from any single board clerk, whatever their size of county, that that's what they want to do, number one. Number two, as I talked about at the start of my presentation, we are a tax trial court. If you look in the Code of Civil Procedure, in Superior Court. Courts, trial courts have authority to sanction people who violate discovery rules and then try and get something in or do something too late. Now, I'm speaking as a lawyer, I'm as open as I believe Breanne is in trying to figure out what the spectrum of consequences can be for failure to timely submit documents. And I'll go out on a limb, it's not much of a limb, and say the county clerks are also open to this discussion as to what is feasible to try and encourage the timely submission. We will also agree and have no problem with what Breanne said regarding the fact that folks ought to know what the rules of the game are, the rules of the road. Yes, absolutely. It ought to be clear if you're going to file an appeal in County X and they have remote hearings and they have a local rule or requirement about the electronic submission of documents in advance, you ought to be able to find that out in advance. But the other side of that coin is you should abide by it too. And where parties are abusing it, they know what the rule is. They've been in that county's AAB system before, and they have violated that time frame before, and they do it again, and they do it again, and they do it again. What happens? Oh, so far what you've heard is the only answer is a continuance. Well, in counties that don't have a heavy workload of appeals, okay, maybe that works. And that's fine if that's what jurisdiction in that situation thinks. I'm all for it, whatever works for them. But it doesn't work for the bigger counties that have much heavier workloads and calendaring needs. What happens, for instance, if you're in a county with a lot of appeals, and every time you have a continuance, the next time that appeal can be heard at the earliest is 6 to 9 months. Not because the board doesn't want to hear it sooner, but because given all the other appeals they're working, that's the soonest it can be reheard for the next hearing. Is the continuance to another day really much of a deterrence to abusers? I respectfully have doubt about that. They're probably quite okay with waiting 6 to 9 months or longer before the next hearing, because it's little or no skin off their nose. So, in summary, due process is due process. Due process is not one kind of thing for a small hearing and something else for a bigger hearing. Due process is due process. The state legislature has said, as a matter of law, a remote hearing is a hearing, just like an in-person hearing. I would respectfully, and the hypothetical, the state board, you hear state appeals. What if you got in your state appeal docket annually between 20 and 40,000 appeals? I know you don't have that many state assessees, but if you did, you got between 20 and 40,000 state assessee appeals of the values that you set as the state board. And you offer remote as well as in-person hearings. And you get a whole bunch of state assessees who tell you and your staff, oh, I can only do in person. Now, if that creates a problem for you because you've got certain timeframes to get your state assessee appeals heard, and you're going to run into scheduling problems if you don't, and you're going to find the state board dragged into court by the state assessee for not getting the appeal heard on time, you're going to go talk to your lawyer, as you should. What is your lawyer going to tell you about your options? I'm not going to speak for Mr. Nanjo and Mr. Moon. If you were to ask them, they'd tell you whatever they they think the law is, and I respect that. But I will also suggest that something that will cross their mind as possible legal advice is that the state board, as the hearing body tasked by the Constitution and state law to hear those appeals, you have a certain amount of calendaring power to make sure those hearings are heard in a timely fashion. And I raise this with you as the state board. I'm basically asking you, put yourself in the shoes of the local AABs as you think about this issue. I'm glad to answer any questions. Thank you.
Thank you. Is Ann Moore available?
Yes, I'm here. Thank you.
Go ahead. Thank you. Welcome.
Well, good afternoon, everybody. Thank you for letting me have the time and when waiting. I'll be brief. I just wanted to speak to you about the San Diego's experience with the virtual assessment appeal hearings and the proposed LTA changes. So again, just for the record, my name is Ann Moore and I'm the Chief Deputy Clerk of San Diego Board of Supervisors. I'll try to be brief, but I do think some things merit some remarks. So as we followed our Board of Supervisors last summer and transitioned to 100% virtual hearings, we did so with the parties' due process rights in the forefront of our minds. We looked to the courts, who are dealing not only with money, but with people's very liberty, and we did our best to emulate their virtual hearing practices while adhering to the same tenets that our in-person hearings do. And we are confident in the virtual experience that we've been able to offer. As I would assume is the experience of most agencies, there were some bumps along the road, but our office has maintained a focus on ensuring that we minimize hearing delay and that the taxpayers are afforded due process even in times when in-person hearings are prohibited by local health code. We ensured that parties could share information and exhibits to the same degree virtually as in an in-person hearings, and we had our staff not only send copies to all the parties, but also share on their screen during the hearings, which turned out to be a benefit because rather than in in-person hearings, parties could be sure that everyone was looking at the same document, at the same page, at the same place in exhibits. We provided for instructions for help with hearing platforms, both on our hearing notice website. We also made staff available by email and phone. We talked through technical issues, which were more often than not user error. And we even had one participant come to the still closed county administration building to use the Wi-Fi. Things have been challenging, but we've worked very hard to ensure that the experience offered parties the same rights and opportunities as in person. In fact, much of the difficulties that we associated with virtual hearings fell on the clerk's office. As previously mentioned within the hearings themselves, the primary issue was handling the distribution of exhibits. And so just as a reminder for context, in our in-person hearings, the parties bring physical copies and distribute them at the time their case is called. Should there be any issue or discussion, they can step aside and the board can proceed to handle other matters. Calendar keeps moving forward and we're able to fully support a larger number of cases at each hearing date. Obviously, in virtual hearings, as you heard from Kata, we're unable to operate in the same way. And so instead, this is all done in real time in Zoom or a Zoom breakout room that's facilitated by one of our staff members. And this is what contributes significantly to the extended time needed for virtual hearings. In an attempt at efficiency, we do try to use the LTA 2021-002, and we require parties to electronically submit exhibits 72 hours in advance. Our office compiles all those exhibits and distributes them to board members and parties via email once the item is called. The challenge is that we don't have the means to enforce this, and routinely our staff are faced with exhibits submitted in the hearing or supplementals submitted just minutes before the item is called. The parties, understandably, because of our backlog, don't desire a continuance, and they both agree the late submission is fine. They're ready to proceed, but without any way or any recourse on our part, the hearing will proceed, but with an extensive delay while our staff deals with the late submissions, because we have to confirm that we received the items or let them know that we didn't receive them and wait for resubmission. And then we have to compile everything and be sure they're complete and distribute them to everybody and confirm that everybody received them, sometimes resending to alternate emails. This process often results with everybody sitting on Zoom for sometimes 30 minutes waiting for exhibits to get where they need to go. All of this could have and should have occurred in the 72-hour prescribed for evidence submission. We recognize that the frequent delays caused by evidence handling in a handful of hearings has a ripple effect on the due process of other taxpayers. 30 minutes may not feel like much to an individual who's been waiting for their hearing, but multiply that across all of our calendars and it only adds to our already heavy backlog. Delays due to late evidence submissions forced us to further reduce the number of hearings that we could confidently set on a calendar and pushed out available hearing dates further into the future. This in turn affects countless other applicants waiting for a hearing date. And we recognize that other counties have handled virtual hearings and exhibit submissions in different ways depending on local circumstances. And we know that some, such as LA, have had the resources to resolve this issue with significant technology upgrades. But for the vast majority, including San Diego, who don't have those resources, we would like a way to set our own rules of procedure to control our calendars in a way that ensures that we are not trading an excessive safeguarding of due process for the few to the detriment of many. I do want to reiterate a point from the last meeting suggesting that the state adopt Los Angeles County's technology and process. San Diego County is the second largest county in the state. We process between 3,000 to 5,000 appeals in a year. Los Angeles County processes tens of thousands of appeals. Comparing Los Angeles to any other county is apples to oranges. We don't have the volume or budget, and we are the second largest county. Giving us a software program that they developed will not provide us the staffing needed to support it. And that's even if we can get it through the security vetting process required by our own county's IT department. Now we have, in conjunction with our Board of Supervisors, transitioned back to in-person hearings, and we're working hard to set the extensive backlog of applicants who requested an in-person only hearing. We're also tracking a number of cases that, since we've returned to in-person, are requesting virtual hearings. Like you've heard from others, we are doing our best to support these requests and fulfill what the applicants need. We even explored the option of doing certain types of appeals or calendars primarily as virtual, but we struggled with how to plan for all the different variations. So instead, we're offering virtual hearings upon request for those who need them because they are high-risk populations for COVID, but notifying that those parties that they may have to wait for a further out hearing date because they're being special set in addition to our regularly scheduled hearings. Finding a full board to take on those additional calendars is challenging right now. I want to note that we do see value in virtual hearings as a mean to continue operations when our local government has restricted in-person hearings. And we see equity and accessibility value in continuing to offer some of those hearings even now. As mentioned, if you're waiting hours for your case to be called, you could be doing that at work. You could be working and not missing time. And for some of our applicants who are hourly, missing a whole day only to have their case continued is detrimental. And we don't want an applicant feeling that they're in a position where because of their own health conditions, they have to risk exposure by coming to an in-person hearing. We plan to continue to offer virtual hearings as long as we're able to, in addition to our in-person hearings. Saying that, it is absolutely infeasible for us to support both hearing types for any reason at the whim of an applicant. This isn't something offered for court defendants with their lives on the line, nor for civil litigants as a matter of right, and it should not be so for assessment appeals. Expecting that from counties who at times are already having trouble filling enough boards to support existing calendar levels will only ensure that the desires of the few will impact the rights of the many, and we simply do not have the ability or staffing to simultaneously administer both types of hearings. Due process does not specify ability to opt into hearing format. We've worked hard to ensure virtual hearings meet due process requirements, and an individual's belief on this is not fact. We will offer what accommodations we can, but we should not be required to support whatever hearing type an applicant prefers. Hearing preference is not a right, and it's not something our boards or staffing can support without pushing hearing dates and due process for the masses. So I ask you again to leave the counties with some trust and discretion. On so many levels, our counties are unique, different sizes, different budgets, different technology available to us. Add on to that the vastly different COVID experiences across the localities, and the needs of each county were unique and evolving based on the ever-changing new normal. We hope that counties can be empowered with some discretion to ensure equity and efficiency for all parties amidst our own locales' unique circumstances. In the end, much like was faced here just a few minutes ago, where there are technical difficulties, we resolve them, just as we do with issues that we face in in-person hearings. We get the hearing done and all parties receive their due process rights guaranteed by law, just as we do with in-person hearings. So I want to thank you for listening. Thank you so much for your time, and I'm happy to answer any questions that you have.
Thank you. Thank you for your perspective. You know, we forget that you're the second largest county, but yet when you compare to LA, it's not as big as we think, right?
No.
And there is a hand from Member Gaines. Go ahead, Member Gaines.
Yeah, so I'm just trying to get clarification on this question of evidence presented.
Yes. Yes.
Right, and because you're describing circumstances where evidence is being submitted late.
Mm-hmm.
And so is that also coinciding with a public hearing, in-person public hearing?
So in-person hearings, they just need to bring the evidence the day of, because they bring paper copies for everybody and they're able to distribute it at the time of hearing. For the virtual hearings, because we have to ensure that everybody is getting those things electronically and they're not getting it prior to when the hearing is called, so there's not, early sneak peeks that would, I guess, give them opportunity to prepare in a way that they wouldn't in-person hearings. We are holding on to that, consolidating it and distributing it right when the hearing occurs.
Okay.
So we are requiring them to submit that 72 hours in advance so that we are able to do so as soon as the hearing occurs and there is no delay.
Okay, and that would be different for an in-person hearing?
It would, yes.
Okay, all right. So is Henry Nanjo available? I'm just trying to I'd like to get clarity in terms of due process. Is due process being afforded to citizens on a per county basis, even though the process may be a different one, right? Because when we look at LA County, a much bigger county, many more cases, and then certainly the San Diego example, and let's take a smaller county, let's say Placer, or how about Alpine, which is a very small county. Can those all be handled differently, and can the due process rights be given to that individual that has the hearing?
Member Gaines, thank you very much for your question. I will invite Richard Moon to join me in this, but definitely due process means that the applicant and the or the petitioner and the assessor side are being treated fairly. And that's being done through a legally viable process that does not require, for lack of a better term, identical treatment in all circumstances. As long as their rights and they have a known process. Richard, would you like to maybe flesh it out a little bit more?
I'd be happy to. I'd be happy to. This is Richard Moon with the legal department. For taxation hearings and for assessment appeals hearings, what's required in terms of due process is often stated as notice and an opportunity to be heard. That's fleshed out a little bit in our rules, but one of the reasons why there aren't specifics is because, as you've suggested, Member Gaines, is that the counties that are holding these appeals hearings range from small counties like Alpine to huge counties like LA, and their needs, the types of cases, their staffing, availability, all of those things may be different. And so there are cases out there that describe due process as one where states, in this case, where boards and counties have great flexibility to satisfy what due process requires, which is that they have a meaningful hearing, that they have an opportunity to be heard, and that may follows one procedure in one county, and another procedure in another county. And I believe the counties have the ability to determine, whether a particular process would afford the taxpayers due process. So due process is absolutely required. The specifics of that may depend on the circumstances and the count, including what counties they're in. I will just add as a note, while the board is considering what may or may not be, or what specific elements may or may not be due process in the assessment appeals context, in the trial courts, in the superior courts, part of their emergency rules for the pandemic have required remote hearings or remote trials for civil hearings. That's not the case for criminal hearings, but a lot of the concerns that have been raised by CADA and the other side as concerns that they're trying to work through, the superior courts, at least, it appears, have determined that they aren't things that couldn't be worked through on a remote basis.
Okay, now what about, okay, let's say you're putting in regulations as a result of COVID and you go remote. Would that be a violation of due process if you were forced into the remote pathway versus in person?
Not necessarily. So there's nothing that says due process requires a taxpayer to have a choice between remote and in person. So as long as the procedures that the counties follow in holding a remote hearing afford the taxpayer an opportunity to be heard. And again, the concerns that CADA raises are definitely concerns. And from what I've heard from the clerks, they are concerns of the clerks as well. And they are attempting to make it so that each taxpayer in the remote hearings have a way around what could be those problems in terms of whether it's having access to evidence or having access to technology or being able to quote unquote read faces or make sure witnesses aren't coached or whatever those concerns may be. Again, there's no absolute right of a taxpayer to have either an in-person or a remote hearing. And I think in the assessment appeals context, Revenue and Taxation Code 1616, as has been cited, makes that clear.
Okay, and if someone felt like they didn't get the necessary due process as a result of being denied an in-person hearing, I mean, could that set up litigation, and then would that set a new precedence?
It could set up litigation. So their recourse would be to file an action in Superior Court stating that they were not afforded due process. The Superior Court would decide one way or the other based on what actually happened at the hearing. And then depending on which way it went and if it was appealed, then it would go, of course, to the appellate courts, and then they would decide. And if that case was published, then that would become precedent.
I see. Okay. Then how about the submission of evidence late?
Yeah. So the Constitution allows counties to set up rules of procedure. And so as long as there's no other state law or state regulation or regulation promulgated by the board that says otherwise, it is an area where the counties can set up their own rules. So in terms of document submission, they could set up their own rules that say, you have to follow a particular procedure, and if you don't follow that procedure, then that evidence will not be accepted. I don't see any reason why a board could not pass that type of procedural requirement. And then, if it were passed by the county board as part of their ordinances, then of course everybody would be on the same page as to the requirements, as well as on notice as to what the requirements are.
And as long as they were reasonable, right? I mean, as long as
Correct.
you had full time, for instance, to make that submission, that's something that could be held for the appellant to bring forward and live by those rules.
Correct. And if an appellant, if a taxpayer felt that those rules were unreasonable, then again, that's something that they would pursue further action on.
Right. Okay. Very well. Thank you. I appreciate that clarity.
Absolutely. Thank you, Member Gaines.
Thank you. Seeing no other hands, we'll go ahead with, is Marcy Berkman available?
Hi, thank you very much for the opportunity to speak today. I apologize I'm not on video. My internet is not strong enough today to hold the connection if I have the video on.
Not a problem.
I represented the Santa Clara County Appeals Board for over 10 years before I retired in July, and have been part of the property tax world for over 20 years now. And today I'd like to address briefly three of the main topics that the board and the participants have been discussing: due process, the hearing type, and late submitted evidence. Briefly on due process, as the board's counsel noted, both the taxpayer and the assessor have due process rights. And really, truly, the assessment appeals boards are the neutral quasi-judicial party. They are just like the judge and the superior court and strive very hard to be that way. And I think that's important because in some of the drafts that have been placed before you, and I think sometimes it's just inadvertence in the drafting, the parties or one or the other of them have used the term taxpayer here and there. And I think it's important that to the extent the LTA is revised, that any such reference should be to the parties, not to the taxpayer, because the assessor is also a party before the AAB, just like the taxpayer is, and just like a plaintiff and defendant in a court, they both have the equal due process rights. I'd also like to correct a statement that Kata made that's not really correct. They said in the vast majority of cases, the assessor really has sort of an advantage over the applicant because they're deemed to have done their job correctly, and the applicant has the burden of proof. But the reality is, in my over 20 years of experience in Santa Clara County, which has a massive number of AAB appeals, even though that is dwarfed by Los Angeles, the vast majority of our cases that go to hearing are single-family owner-occupied cases. And in those cases, the assessor has the burden of proof and the burden of going first. And so really, truly, when you're talking about due process, it's both parties. And even among the minority of the cases that go to hearing in Santa Clara County, the commercial cases, in a fair number of those, it's an escape assessment or the assessor seeking to raise the value. And there again, the assessor goes first and have the burden of proof. So really, truly, when we're talking due process, we are talking not only constitutionally, but practically about making sure it's afforded to both parties, and that one party shouldn't have control over the other, over how things go. That really is something that needs to be left to the board, and it's to the board and the clerks of the board to do their best under their circumstances in their individual county to offer due process to both parties and do their best to do their job. Moving on to hearing type, although I can no longer speak for the county because I retired in July, I do speak from my experience as the county's AAB. And my position is somewhere between Kato's position and Kakio's position. As your counsel and Mr. Parker mentioned, early in the pandemic, your counsel advised that yes, the rules do permit for a remote hearing, and then the state board generously assisted in getting RTC 1616 changed to clarify that a remote person is a hearing. And so the law now, as Mr. Parker pointed out, is that whether your hearing's live or remote, it is a hearing and it constitutes due process. And as your court counsel pointed out, the courts have been using remote hearings in order to get us through the pandemic and civil litigation. That said, as this board heard me say early and often, even before we went to remote hearings, I do agree with Kata on a great number of their comments about, in some circumstances, what makes a live hearing better than a remote hearing. And I know that the Assessment Appeals Board members and hearing officers that I worked with, the vast majority of them felt that they could do their job best, especially in a complex case, live and in person, for many of the same reasons that Brianne expressed on behalf of Kata. And while it's true that remote hearings do seem to work simplest from our experience, in administrative matters like continuances and reinstatements and approving stipulations and pre-hearing conferences, and in less complex cases like a really simple single-family homeowner, although even that's not easy. I do disagree with Kata's suggestion that the state board issue guidance saying use remote hearings only for administrative things and hearings that qualify for a lead hearing officer. As Mr. Parker pointed out, the ambit of what can be covered by a remote hearing has already been set by the legislature, and that is any type of hearing can be remote, and that gives you due process. Two other points that help illustrate some of the problems in Kata's proposal, that only things that qualify for a hearing officer be permitted to be done remotely. There are, for example, many small local businesses. Car washes are often valued at $1 to $5 million. Local restaurants, local boutiques, those would fall over the $500,000, the $500,000 limit for qualifying for a hearing officer. But in some cases, they may be fairly simple, straightforward matters that could quite well be heard by a remote hearing if both parties in the board felt that was a good idea. Similarly, there could be something like a small six-plex residential building that might be a straightforward comparative sales analysis and very simple to present at the road, but does not meet the requirements for the hearing officer. And on the other hand, we're now looking at a pandemic that's coming on 2 years long, and some counties have probably been closed for most of that 2 years. In Santa Clara, we've gone back and forth between live hearings and not live hearings, depending on the public health orders. But easily at this point, we can see COVID might take a turn where we're closed down for 2 years. And really, a lot of the issues about value on the roll and getting things heard stem from the large corporate taxpayers. In Santa Clara County, for example, we have Levi Stadium, we have Apple, we have huge department stores, things that take up a vast amount on the roll. And those types of taxpayers tend to be represented by very sophisticated tax agents who are savvy enough to know how to game the system and either put 0 as the applicant's opinion of value or a small fraction of the roll value, knowing that if the 2-year statute passes, that will allow them to have their 0 opinion of value entered as the roll value. So the problem if the state board were to say taxpayer can reject or assessor can reject a remote hearing, and you just have to wait till a live one's offered, is there's the possibility of the 2-year statute running. And the entire reason we started having remote hearings in the first place was to make sure that cases get through the system. There isn't a backlog. We don't end up with cases running the 2-year calendar. So anything that's done needs to be make sure that if for whatever reason you can't have your hearing now, maybe the AAB is saying, we'll give you a remote hearing now, but if you want, you can postpone till we can have a live hearing whenever it is our public health officer lets us do that. There needs to be a provision for waiver of the 2-year statute involved in that, because otherwise we end up, if it's a world that Kata wants where they can demand a live hearing if they don't want remote, there needs to be a statutory waiver that goes with that, because we can't have these large taxpayers represented by tax agents gaming the system, and playing games with we are or are not willing to take a certain type of hearing, because any hearing is a perfectly good hearing that provides due process. Finally, moving on to late submitted evidence, there has to be teeth to enforce that people follow the rules. And if you were to adopt Kata's suggestion that for every applicant or assessor who fails to timely submit their information, you allow a 45-minute delay, the AAB will never get through its calendar. There's often 25 to 200 items on the calendar, and maybe 10 to 30 of those will be a live value hearing on any given day. And both from the AAB and the clerk's perspective, you can't hold up the agenda. You can't create chaos for the hearings and hearing clerks that way, and the assessment appeals board, or for all the other people who are waiting in line for their remote hearing to happen that day, standing by for their case to be called and be the one up at bat. I don't think anyone is really suggesting at this point, although your counsel said that if a rule were to be passed, it would be appropriate. But I don't think so far I've heard anyone actually suggesting that what the AABs want to do is exclude evidence. I think from my perspective, the proper way to proceed if a party doesn't timely provide their exhibits for a remote hearing would be to continue the hearing to another date. And if it's the taxpayers whose exhibits are late, then the taxpayer should be required to sign a waiver of the 2-year statute. And that's their, penalty for not timely complying. You're going to have to wait longer for your cases, to be heard. And it's a shame that people will play games that way. If it's the assessor that messes up and doesn't get their exhibits in timely, I would suggest that there should be no waiver on such a continuance unless perhaps it's within 120 days of the 2-year deadline, in which case it would seem, I think, appropriate to require a waiver in that. And I think it would be appropriate to leave those types of procedural requirements up to each jurisdiction and its rules of local notice and procedure for how they're going to handle them. But I don't think anyone at this point is suggesting that the remedy is to exclude evidence. Ms. Rabowski also mentioned evidence that comes in on rebuttal and impeachment and correction, and disputes between the parties of whether or not that should be accepted. Those kind of things happen whether it's a live hearing in person or whether it's a remote hearing. And just as they do in live hearings and a remote hearing, it's the AAB's discretion of what to do and decide, is this really appropriate rebuttal and impeachment evidence? Or is this something that the other party is trying to sneak in late? And even if the latter, do we want to consider it because our constitutional function is to get to the right value? Those are all the board's decisions. And sometimes in a live case, there might be a half hour of bickering of whether it's appropriate to submit a rebuttal exhibit or not. And I have more than a few times seen my board say, we will take it, but we will give the other time, call you back here in 2 weeks or in 6 months or whenever, because that's our next hearing date, so that you can comment on the rebuttal exhibit, because we think it's information we should have, but we're not really sure that it should have come in at this point rather than earlier. And so I think whether you're talking remote or live, the AAB has the same discretion. The AAB is used to that. I don't think there's really any need for guidance on that particular issue. And that concludes my comments. I'm open to questions if anyone has any. Thank you.
Let me just seeing no hands or comments, I think we're good. Is Kathy, is it McClellan? Did we lose her?
Mr. Chairman, John McKibben,
Yes.
I believe that Ms. McClellan may have retired. I know she was coming up on retirement, had been sticking around longer than she had intended, and she has not answered any emails for the last week or so. So I believe she may be retired. I doubt if she's going to be on the line today.
Oh, so we took too long. Is that what you're saying? Okay. Is Miss Karine Gonzalez available?
Hi, yes, I am available. Thank you so much.
Welcome.
Thank you. I will be probably the briefest of them all. I think that what I would like to reiterate today is a little bit of the opposite side. I am the AAB clerk for the County of Sonoma. I'm the deputy clerk of the board, and as such, I'm the clerk for the AAB. We're a medium-sized county. I am the only AAB clerk. We are shorthanded across the board, and we have just lost an AAB member, and so we have 2 open seats. That being said, our calendars and our agendas are incredibly valuable, and when we have postponements like we've had because we have taxpayers and individuals requesting a certain type of hearing, it just kicks the can down the road and makes our job even more difficult. We don't know what the future holds, just as we didn't know this pandemic was coming and we had to shut down. Sonoma County has been holding remote hearings since May. We canceled our April hearing and started doing remote hearings in May. We had another fire, so we canceled one. And then last month we started holding in-person hearings. Recently, I got an email from an agent requesting, actually demanding, I quote, "We demand a remote hearing." And the reason is because they can't make it to Sonoma County. So what I'm dealing with right now is taxpayers and agents demanding and then citing the LTA, the 0002 LTA. I would like to, document submission has not really been for the County of Sonoma an issue. What has been no more difficult in receiving the documentation for remote hearings as it would be to receive them in person and making all the copies. Really for us, for the County of Sonoma, we really haven't experienced a lot of that. But I can say that if we didn't receive the evidence or any kind of document for a remote hearing in time, what we had done and what the board did do is postpone. We haven't had any backlash from that, and we have postponed the hearings. Again, I'm the only AAB clerk, and all it does is kick the can down the road for us. I agree. John had mentioned something earlier, and I just want to kind of reiterate the importance of it. I have an agent now that I stated who is demanding a remote hearing. Well, what if the assessor says this is too complex, or this is going to be, a hearing that we really want to have in person? Who gets to have that hearing? Who gets to decide? So I think it's really important that an AAB clerk, such as myself, really handle their own calendar. We are the ones that touch every single application. We're the ones that communicate all the time with both agents, assessors, and taxpayers. And as Mr. Moon had stated, the courts have used remote hearings for civil proceedings. We are a quasi-judicial board, and there would be no reason for AAB to continue remote without losing the right to due process. I also have tried to accommodate. Never once have I refused a type of hearing. Right now, we're not holding remote hearings. We're trying to figure out what the best format is down the line, what kind of hearings and things like that, kind of waiting for you as the board to make a decision, possibly amend the LTA. And just as I believe Ann Moore was stating that, Ms. Berkman was stating that, I do agree with Kata too, that some hearings are necessary to be in person. But I don't believe that it is their choice to make that decision of what kind of hearing. We will do our best to accommodate. They use terms like full and fair, reasonable opportunity to be heard. All of our remote hearings, they have had ample opportunity and reasonable accommodations to be heard. In fact, with our remote hearings, because of the format, they're actually afforded a little bit more time as opposed to what they may be able to be heard in person. So I will end with that. I appreciate your time. I don't want to take up any more. All I would be doing is kind of mimicking what has already been said, and I do appreciate your time.
Thank you, and I appreciate your brevitivity there. Did we lose Mr. Dronenberg, or is he still with us? I think we might have lost him. So with that concludes the 7. I just had one quick question for Mr. Parker, if he's still available, and it's on the rights of the hearing participants. Can you explain the difference between the indefinite time waivers in your proposal and the agreement to toll indefinitely the 2-year limitation period?
They're the same thing, Mr. Vasquez. Terminology for the same thing.
Thank you.
Thank you, sir.
And then the second question I had for you was on the document submission issue.
Yes, sir.
Since remote hearings require more time to upload documents, would it help to require the parties or the assessors and taxpayers to submit them further in advance?
It might well, sir, depending on the methodology by which documents are electronically submitted. I hate to sound vague, but for the LA system, you don't need more than 3 days, unless you're asking the AAB clerk staff to do the inputting for you. And if you're doing that, we need 7 days. But the systems vary is the short answer, sir. I wish I could give you a more precise answer than that.
No, I appreciate it. And then I guess the last part of that would be, and if they don't, what options have you considered for, I guess, the potential consequences?
Well, really, I can only, I've not heard any clerk, including the clerk in my county, come up with a specific proposal for what the consequence is, or should be, or could be. I haven't heard, as I said earlier, I haven't heard anyone talk about exclusion of evidence, say we want to do that. I haven't heard that from anybody. But I have heard that the mere continuance, certainly in Los Angeles, the mere continuance remedy really doesn't serve as much of a remedy, to be honest.
That's what I thought. Okay, thank you.
Thank you, sir.
Any other comments or questions of any of the 7 speakers, or I guess 6 now that are, well, no, I think we're down to 5 actually. If not, do we have any comments or questions from any of the members of the working group of any of the speakers? And I see a hand already from actually our member Cohen. Yes, go ahead.
Yes, thank you very much. And I just want to recognize, oh, Ryan, you're still here. Just recognize all of the speakers and their presentations. I really appreciate it. It's very evident that you have taken this seriously. And it's very interesting how when we initially started this conversation, we were just kind of touching on the surface. And over time, within the last year, just being able to dive down deep, peeling back the layers to having a really robust discussion. It is my hope that we will be able to come to an agreement, come to even a piece of policy or a way of doing business that will provide a lot of insight and make things easier. My intentions in engaging in this process is not to make life difficult for people, the assessors, the stakeholders, the AAB clerks, the taxpayer advocates. I'm actually engaging in this, just trying to streamline. And I also recognize that we're almost talking about a cultural change, changing how the culture of business has been done. And cultural changes are difficult, but I think it's important. You either change or die, to put it quite bluntly. So, one of the things, again, my goal was 2 goals: to protect public health and the preservation of due process rights for all the parties concerned. And it's in that context that I was listening to these presentations. And the question that I was originally going to start with was if the clerks and CADA in particular in the state could, if they were able to come to some kind of agreement on proposed language. Now, Ms. Romanowski, you had said something I think that I'm going to pick up on, and I actually probably have a motion fashioned in my head, and it's almost selecting a time for us to get together and go line by line to really figure out where the point at issue is. And I want to say that I know that's going to be time consuming and probably very grueling, but if we commit to doing it, we will only have to do it once. And we could really begin to tackle some of these, some of the challenges. Does anyone have any comments that they want to say? If not, I can go on. I have lots of notes to talk about.
Member Cohen.
Vice Chair Schaefer, go ahead.
Ms. Roboski has to leave in about 1 minute.
So let's let her respond.
I do have to leave. I apologize for the very
Okay.
hard stop today. I agree with Ms. Cohen. I think going line by line will help elicit the differences. CADA does have responses. I have many responses to the things that were presented by the counties today. So we would like an opportunity to respond, and we look forward to continuing to work on this issue. So thank you for including us today. I apologize that I'll have to sign off, and I trust that my other members off the Teams line are listening. Thank you so much. Have a great afternoon.
Thank you. So just, you can definitely step off, but I was going to give some of my closing remarks. And Mr. Chair, thank you, and colleagues, thank you, especially the stakeholders who've all participated in this hearing today. I believe that what we need to do is continue this hearing through a work group and have another notice hearing to attempt to narrow down any remaining disagreements among the parties. Like I said earlier, going line by line. And I want to acknowledge that this may be a slow and a cumbersome process, but I think it's in the interest of all parties that we want to do the right thing when it comes to the health and due process rights of all the participants in the AAB hearings. So what I'm proposing is and suggesting that the next meeting take place separate and apart from the board meeting. Separate and apart from the board meeting. The chair's office and my office will gladly participate in this publicly noticed meeting. We can conduct it line by line and see if there is consensus, and then we could recommend next steps. Theoretically, the earliest 10-day notice could be sent after October 20th. Which is the conclusion of this board meeting, and that would be on October 21st for a working group that would meet on November 1st. These are dates. Stick with me, Ted. I know you're probably had your fill of this, but I think that it's important work, and it should be publicly noticed, and we should be doing something acting outside of the scheduled board meeting, which is the next scheduled meeting is November 16th. We can meet on any weekday other than November 11th, because that's Veterans Day, from November 1st through the 15th. So the sky is wide open on that. The working groups could meet after November 16th and 17th board meeting and prior to the December 14th and 15th board meeting, recognizing that Thanksgiving holiday occurs on November 25th and the 26th. So after hearing these comments from my colleagues, I'd like to make a motion. Should I just jump right in, Mr. Chair? Make that motion?
I don't see any hands or comments, so if you want to go ahead and continue.
All right, let's go ahead and make the motion.
Oh, wait, I missed
Ms.
one hand.
Stowers.
Ms. Stowers. Oh, I'm sorry. Go ahead.
I'm sorry.
She's jumping around. All right, go ahead.
Yeah, see me. Would the work groups include BOE legal, BOE tax staff? If we have so many, are they a part of this process?
That's a really good question, and I am under the impression that the answer is no. I don't think that they are involved in this. Let me double check. And I don't know if BOE legal is on the call to help.
The reason why I ask is, Mr. Moon raised some very good points as far as what is due process, and Mr. Parker raised some points about what we can do with the guidance and what 1616 says.
Okay, so I see Henry on the screen.
Yes, thank you. Thank you, Member Cohen. BOE Legal would be happy to join and help. I am a little constrained with my staff because we are in the middle of state assessed appeals season, and there's a lot going on, but we will try to accommodate whatever schedule the board would like to endeavor to.
So members, thank you, Chief Counsel. Members, this is Brenda Fleming, Executive Director. So let me offer this. So if Member Cohen's recommendation is in a work group based upon the framework for the work group, it's designed to have a limited number of BOE agency staff involved. And so I think what Ms. Cohen is trying to do is honor that portion of the framework for that organization, for that structure. To the extent that the work group is going to convene and a time frame between now and prior to the November 16th and 17th board meeting, then that would be definitely separate from the board meeting. the work group in that kind of configuration or that kind of schedule could meet, because you're just having the conversation to do a study of the material. There's no decisions being made. So if we're following kind of the precepts of the work group, there's no decisions being made. You're just collecting the information. Now, we could attach, some legal to it, but they're not necessarily anchored to the meeting in the same way that they would have to participate in an interested parties process, et cetera. To the extent, if I'm understanding what Ms. Cohen is suggesting, if the work group is just going to convene with the stakeholders as a discussion body to come back and advise, their draft or their suggested language can then be submitted to the agency so the legal can still review it.
Right.
So be almost like a stakeholder document that is being presented back to legal for review. So that's one way of considering it. The other way to consider it would be you have this work group and legal are required to be there or be participating, depending on how long that is. The challenge that we have, as was indicated, we're in the middle of appeals hearings and this is the same professionals. And I just literally can't put them in two locations at once. So it really is that kind of an issue at this point. So we do want to participate because ultimately the LTA is a legal document that comes from the board. We are the policy setters, and we would need our legal to do it and to get involved in it along with the tax program, because we've got to administer our aspect of it. And policy is our responsibility. So if you're going to have it prior to the November 16th, 17th meeting, then the work group could, according to the framework of your board work group, you can have that kind of advisory, that kind of a discussion and come back with advice or recommendation for a document.
Thank
so
you.
Just wanted to clarify that.
Thank you.
Member Cohen,
Yes.
I'm not intervening lightly here. I'm on a long planned holiday out of California from October 29th through November 14th. So if to whatever extent you anticipate I would be a part of this, and it's something I am generally glad to be a part of, given I've been involved for a long time now, I just want to let everybody know I'm not going to be around till November 15th once I leave October 29th.
So Tom, 10/29 to 11/15?
11/14. I'll be back on the 15th.
Okay, just to clarify, thank you.
Thank you. And I don't mean to spoil plans here, but this is a long planned family vacation.
And I see a hand still, Member Cohen from Member Gaines. Let me just bring him into the fold here. Go ahead, Member Gaines.
Oh, yeah, thank you. So I just wanted to clarify, it sounds like Aaliyah's proposing a work group meeting prior to our next board meeting. So we would gather as a board and I guess finish the hearing, but also look at the working out any issues of potential dissension. You would do that in that work group meeting, and then it would come back to us.
Yes, that is right.
Yeah. Okay.
Yes.
All right. Yeah. No,
Right. So,
what are your thoughts now?
like my thoughts now are, correct me if I'm wrong, but you choose to be a part of the work group, right, Mr. Vasquez? Members could choose not to be part of the work group, and we could bring that finished or draft back to the full body of the Board of Equalization. But that, that's up to you if people want to participate. If you don't want to, I have no comment on that. Tom's schedule does concern me a little bit because he's deeply entrenched in this process and has a lot of wisdom and perspective.
And if I may, Member Cohen, your comment. So if you're following the rules for the work group structure, it would still be publicly noticed. So as you're publicly noticing it, you're acknowledging Bagley Keene, at which point all 5 members could participate. According to the framework for your work group, you're not required to have all 5, but it's still publicly noticed. So I think there's an expectation that there will be some level of participation, but you at least need at least one or possibly one member to chair, or possibly 2 as co-chairs. So in this case, I would assume that it's a continuation of you both as co-chairs for this item, and that would continue. Then it's an issue of if the other members, want to opt in, to participate. It's still, I just want to know, it still is going to be publicly noticed. That was part of the foundation of your transparency principle attached to these work groups.
Right, that's exactly the point that I was trying to highlight. So to members. Okay, so let me make the motion, and then let's have discussion on the motion. And then if there's public comment, we'll take public comment, and then, you know, we still have another item that we have to get through, the Wine Institute issue. So what am I see here? I'm making a motion that this public policy hearing on remote assessment appeals hearing, that it be continued as publicly noticed, as a publicly noticed board working group with the task of conducting a line-by-line review of the proposed language for amending LTA 002. And that this board working group meets separately from the regularly scheduled board meeting. Now, I'm not prescribing a date to it, but that is the motion. The next hurdle we have to get through is, when do we schedule this working group? So that is my motion, to have the working group meeting, have the working group convene, conduct a line-by-line review of the proposed language to amend LTA 002.
Member Schaefer, I would second your motion.
Thank you, Bob.
Any discussion on the motion? Mr. McKibben, you had a hand up, but I don't know if it was related to this motion, though.
I will wait until the second part comes up when we talk about the date, possible
No
dates.
problem. Thank you.
And, you know, in this motion, we could also say at a time to be determined. So a motion has been made, it's been seconded. I guess we'll take public comment, and then we'll take a vote.
Ms. Taylor, do we have any? Oh, I guess we can check with AT&T if there's anybody on the line who wishes to speak on it.
Yes. AT&T moderator, can you let us know if there's anyone who wants to make a public comment on this matter?
And if you do want to make a comment, please press 1, then 0 at this time.
Lydia's doing your counts.
And we have no one queuing up at this time.
Okay.
Thank you. So with that, I guess we can go ahead and call the roll on the motion. Ms. Taylor, I guess you have it to repeat it?
Yes. Ms. Cohen's motion was to continue today's public policy hearing and for the work group to conduct a line-by-line review to amend LTA 2021-002 and meet separately from the board at a date to be determined.
Correct.
All right.
Members, this is Brenda Fleming. Sorry for the interruption. So just want everyone to make to separate from the board or from the board meeting. So I just want to make sure that their language in the motion is correct. Their recommendation I did not hear was separate from the board. It was from separate from the board meeting, from a regular board meeting date. So notice the difference between the date and the entity.
Right.
And then also I would suggest, if I may, members, forgive me, do you want to suggest that you're saying you're working on proposed amendments to the LTA, so that will come back to the board, or just make the distinction of whether or not you're actually drafting the LTA? Just for succinctness for language, so that we
are not drafting the LTA. We're going to go through line by line and make suggested changes and bring them back to the full board.
Okay, just want to make sure that so the language in the motion is very clear.
Right. Yeah, we would need, I think, more to do that.
Yeah.
All right. If there's clarity,
I think we're good. We're good. Let me have Ms. Taylor call the roll.
Chairman Vasquez.
Aye.
Vice Chair Schaefer.
Aye.
Member Gaines.
Aye.
Member Cohen.
Aye.
Deputy Controller Stowers.
Aye.
So that's unanimous of all those present. With that, Member Cohen, you mentioned, you know, we still have, I think, one more item on this still.
Yeah, we do.
Taylor?
That's why we need to keep moving. We got 45 minutes. We got to take on the wine industry.
I know. Well,
Yes.
let's go ahead. Ms. Taylor.
Okay. The next item is N, And public comment on matters not on the agenda. Is that what you're expecting?
I thought there was one more. Are we done then?
There are several more sub-items for the AAB hearing. So we're going to continue with that, or we're going to try to wrap up the agenda at N and then move on to the wine grower. There is a hard stop at 4:45 today for our captioner.
I would like to ask the chair to maybe suspend where we are on the agenda and go straight to the wine industry, the board work groups.
That's what I was going to suggest, because in your marks earlier, I think you forgot there's still some others, but if people are comfortable with it, why don't we suspend that until the next meeting in November? Is that okay?
It's okay with me, yes.
I see heads nodding. Okay.
Chairman Vasquez, sorry, this is Henry Nancy, Chief Counsel.
Yes.
The N item must be heard today because it's a Bagley-Keene requirement.
I got that.
Comment on matters not on the agenda, so I just want to make sure the board is aware of that before you lose quorum.
That we will do.
Thank you, sir.
So while I have you on the line though, Henry, do we need a motion, I guess an official motion that we're gonna table the rest of the items minus N?
That would be a good idea, sir.
Yes,
Okay.
yes.
So let me move that we table the rest of the sub items that we didn't get to today till our next meeting, with the exception, well, no, and then we will hear our N item, and then we can move into the working group on the Wine Institute.
I second the motion.
Okay, it's been moved and second. Seeing no hands or comments, if we can get Ms. Taylor, well, Ms. Taylor, do we have to check with the public on this one?
Yes.
Let's see if anybody's in the public.
I wouldn't think so because this is internal calendaring. I don't think the public has anything to say about it.
Chairman Vasquez, this is Chief Counsel Henry Nanjo. It is an action that the board's taken, so Bagley-Keene does require public comment before the board.
That's what I
takes any
thought.
action. Thank you.
Okay. Go ahead, Ms. Taylor, if you could just check with AT&T to be safe.
Certainly. AT&T moderator, can you let us know if there is anyone who would like to make a public comment on this matter?
And once again, ladies and gentlemen, if you wish to ask a question or a comment, please press 1 and 0 at this time. And we have no one queuing up at this time.
Thank you. With that, members, let's, you know what, why don't we go ahead and let's go to the N item because we can get through that real quick, and then I'll turn it over to the working group on the Wine Institute.
Chairman Vasquez, we do need to vote on your motion to table.
I'm sorry, you're right. I forgot I didn't call the question. Ms. Taylor, if you please call the roll on the motion.
Certainly. Chairman Vasquez?
Aye.
Vice Chair Schaefer?
Aye.
Member Gaines?
Aye.
Member Cohen?
Aye.
Deputy Controller Stowers?
Aye.
So that's unanimous of all those present. Now, Ms. Taylor, I think it's okay to go ahead and just do N first, right? And then we can get into the work group.
Yes.
Why don't we do N, because that should be real quick.
Thank you. The next item is N, public comment on matters not on the agenda. Persons who wish to address the Board of Equalization regarding items not on the agenda. Please note that the board cannot take action on items not on the agenda. However, the board can schedule issues raised by the public for consideration at future meetings. AT&T moderator, can you let us know if there is anyone who would like to make a public comment on this matter?
And ladies and gentlemen, if you wish to make a comment, please press 1, then 0 at this time. And we have no one queuing up at this time.
Thank you. With that, let's move, or Ms. Taylor, I guess you can call the next item then.
Our next item is the board work group on wine industry and wine grower excise tax data. Discussion of issue, options, and possible action to address concerns raised by the Wine Institute regarding access to wine grower excise tax data. This work group will be presented by Ms. Cohen and Vice Chair Schaefer.
Member Cohen, you have the floor.
Thank you very much. First, just want to defer. Mr. Schaefer, do you have any comments that you wanted to make before I got started? Okay.
Yes, Member Cohen, thank you.
Okay.
I want to thank you and your staff for working with our office and trying to find a workable solution to the wine group growers. The industry is near and dear to all millions of Californians. It's one of our major industries, and
I'm sorry, Member Vice Chair Schaefer. I've been informed that we need to adjourn the board meeting before we open the work group meeting.
Okay.
Okay.
So just, I'm sorry, members, excuse me, you can recess the regular board meeting and then convene the work group meeting and then adjourn the work group meeting. If you want to come back after the work group, resume any closing comments. That's option one. Option two is you can adjourn the regular meeting, go to the work group meeting and then adjourn, and all items will be settled for today. I'm just giving you the option in the event that you have any comments that you want to make before you actually adjourn the regular meeting. So you do have that option.
We don't have comments for that. That's not what we're doing.
okay,
So if I'm hearing you correct, we could adjourn this regular meeting, get into the work group. Do we need to come back on any decisions from the work group, or can we just end that meeting?
We're establishing the work group as its own public hearing. And so the rules are made succinct. So if you just want to take up the item today and you want to take it for discussion only, then you can do it that way. If you are taking up this work group today and there's going to be actions or decisions that come back next month, you would just recess. You would finish up the work for today and then just continue the discussion at the next month's meeting. So it depends on what your actions are going to be. What I'm doing, sir, and members, is making the distinction between the regular meeting and the work group. Because in the rules that we established, and I'm just making sure that Ms. Garrett is tracking me on this and can correct me, that we're making a distinction between those two forums. So you can either recess one and convene the other, or you can adjourn the regular meeting and be done for the day.
Well, let me ask Member Cohen, are you requiring any action on your work group today?
Am I requiring action?
Or are you going to ask, I should say?
Well, I mean, I was trying to push and get as much of this agenda done as I could by 5 o'clock. But now I'm told that we only have to 4:45 because the closed captioning person has to go, which is now just 20 minutes away. So no, I don't even think that we will be able to get to an action item, but I do want to get on the record talking about this item. We will have to definitely bring back in the next meeting, or schedule a work group meeting at a later date.
Okay, well, hearing that, why don't we go ahead and just adjourn the first meeting and then we'll move into the work group. So I think we already had an adjourning motion from Member Gaines. Is there any other closing remarks from folks before we close out the first part of our meeting here? Seeing and hearing none, we will officially adjourn our meeting at 4:22. Our next meeting is scheduled for November 16th. I believe 16th and 17th for right now.
That is correct.
So with that, we will officially adjourn and stay on so we could move into our work group.
Convening the work group, that is correct.
Okay.